All righty, good morning, everyone. Morning, sir. I will call the matter of the state of Wisconsin versus Ernest T. Hopkins, 19 CF 756. Appearances, please.
The state appears by Carly McNeil.
All righty, thank you. Good morning, Ms. McNeil. Mr. Hopkins, are you Ernest T. Hopkins? All right, thank you, Mr. Hopkins. Mr. Hopkins, it's my understanding that you are eligible to be represented by an attorney from the Public Defender's Office. But even though an attorney was present for your initial appearance, an attorney to represent you going forward has not yet been appointed through the Public Defender's Office. Do you understand? Okay. Now you have a right to have this hearing held today. You have a right by statute to have a preliminary hearing held within 10 days of your initial appearance when you're in custody on a felony case. But you also have the right, if you wish to have an attorney with you and representing you for the preliminary hearing, to waive that time. This court will toll the time, and then we'll schedule or calendar your preliminary hearing later on down the road so that you could have a lawyer representing you instead of being required to represent yourself, which would be the case today. Do you understand? Now, it's up to you. I don't recommend that people represent themselves in criminal cases, but you have a right to do that if you want. And again, the other option would be for you to waive time. I'll toll time so that you can have an attorney appointed to represent you. You understand?
Commissioner, I'm sorry to interrupt you, but because he's muted, we can't hear his answers.
Oh, okay. I'm sorry. There we go. Okay. Yeah, thank you. All right, Mr. Hopkins. Again, like I just indicated, you have a right by statute to have the preliminary hearing held today. You have a right to have this hearing held within 10 days of your initial appearance when you're in custody on a felony case. However, you also have the right to waive the hearing. And in this case, to have a public defender appointed attorney represent you rather than being required to represent yourself today. So again, you understand those the options for you today?
Yes.
All right. What would you like to do today, sir?
I would like not to waive it.
You'd like to waive it or not?
No.
You want to
Not
represent? You're going to represent yourself today?
No, sir.
Well, that's the only way it's going to happen today. You either represent yourself and not waive it, or you waive it to wait for an attorney to be appointed. Otherwise, you'll have to represent yourself today.
I like. Yeah, wait till I do the attorney. I'll wait till I do the attorney.
Okay, Mr. Hopkins, let me explain it again. If you waive, you're only waiving the time limits today. You wouldn't be waiving the hearing, and you waive the time limits if you want to have an attorney representing you going forward, including for the preliminary hearing. If you don't waive the time limits today, then you'll be required to represent yourself today for the preliminary hearing, because the hearing will have to be held then today. You understand?
Oh, all right. I like to waive the time limit.
Okay, because you want an attorney to represent you. Is that correct?
Yes.
All right. Okay. Then based upon Mr. Hopkins' understanding, knowingly and understandably waiving his right to have the hearing held today, waiving time limits, court will toll time, the time limits for cause in order to counter the preliminary hearing out beyond the 10-day statutory limit, so that Mr. Hopkins may have counsel appointed and representing him going forward.
Coming back here for an attorney status on July the 23rd at 1 o'clock. Thank you.
Thank you, Mr. Hopkins. We'll see you then, and hopefully you'll have an attorney by then. Then we'll schedule your preliminary hearing. Okay.
All right. Thank you.
Thank you, sir.
I'm just waiting. I think this is this person. Okay, to the person whose phone number ends in 1890, may I have your name, please?
Brian Jones.
Okay, Bryant, thank you. What I'm going to do is your attorney is on Zoom with us now, but he does want to talk to you just a little bit before the hearing. So I'm gonna put you in what's called a breakout room. When you're done, just stay in that room. Attorney Barth will come back to our hearing and I'll take you out of that room, okay?
Okay.
Okay. There you go, Mr. Barth. Good morning, Attorney Berman. Attorney Berman, will you need to speak with Mr. Winkles?
No, but I believe I'm going to need a breakout room to have a sidebar with the commissioner.
It'll take a second here. I'll put you in that room. I assume you want Miss McNeil in there with you?
I do.
Okay. I do have one other attorney in a breakout room, just so you know who's got someone on the phone. So if he finishes and suddenly I close all the rooms and you go back to the main screen, I'll put you back in a room.
Sure.
But that's
not
the
a
only way
problem.
to get that person off the phone out of a breakout room, okay? So
Yeah,
give me
I
a
understand.
second here
Take your
and I'll
time.
send you all to that room. Alone.
Dave, is Berman logged in yet? Or no?
He is. He doesn't want to talk to Winkles.
He doesn't want to?
No, but
Okay.
he's talking back there with him.
Okay.
So, yeah.
Gotta go out of town this weekend?
Waukegan.
Oh,
So not too bad.
that's not bad.
Yeah.
I have none, yeah, for 2 weeks.
What do you want to maybe like? Talk about for 5? Right. How do you feel? Okay. We'll do that then. Good. All right, cool. All right, thanks a lot. Yep. Bye-bye. Thanks. Are we ready or not? No.
I don't know if he's gonna end up having it. Well, if he is ready, we should go then, because his calendar's super.
All right.
So I'm guessing there's no victim meeting.
we're able to call the case right now?
Yeah, there's no victim.
Okay, great. All right, then we'll call the matter of the state of Wisconsin versus Tony A. Winkles, 20 CF 615. Appearances, please.
The state appears by Carly McNeil.
Commissioner, good morning. May it please the court, the defendant, Tony Winkles, is appearing via Zoom video conference, represented by attorney David Berman, also appearing via Zoom video conference.
All righty, thank you. This matter is on for preliminary hearing. Let me just pull up a couple of things. In terms of the preliminary hearing, what's the status on that, Mr. Berman?
Commissioner, there's going to be a waiver of the preliminary hearing in this matter. I did have prior discussion with Mr. Winkles about that. I did go over orally a waiver of preliminary hearing form with him, as well as the preliminary hearing waiver plea offer form that was presented by the district attorney's office. The waiver offer is plea as charged. State will make no specific recommendation at sentencing. It is subject to further negotiations and open until the judicial pretrial and is subject to bond compliance. I discussed that with Mr. Winkles. Based on that, he is willing to waive his right to a preliminary examination this morning.
All righty, thank you. Ms. McNeil, was that a correct recitation of the offer?
That is accurate.
All right, thank you. I also see that you have a bond motion that's been filed. We'll take that matter up after the waiver hearing here, Mr. Berman.
All right, thank you, Commissioner.
All right, thank you. All right, now, first off, I assume, and I'll ask you, Mr. Berman, you had enough time to discuss the offer and the details of the offer with Mr. Winkles, is that correct?
That's correct, I did.
You also have enough time to discuss with him the waiver of the preliminary hearing and the impact that will have on his case?
I did.
All right, great, thank you. Good morning, Mr. Winkles.
Good morning,
You're in the
Judge.
courtroom with me here, so I'll speak directly to you. First off, are you able to hear me okay?
Yes, absolutely. Yes,
great.
sir.
If there's a point where you can't hear me, please let me know, okay?
Absolutely. Yes, sir.
Next, are you thinking clearly today?
I'm sorry?
Are you thinking clearly today?
Absolutely, Your Honor.
Now, did you just hear the plea offer that your attorney, Mr. Berman, placed on the record?
I don't know if I understood it completely. I kind of get the idea that I'm waiving my preliminary hearing today so that way we can move forward in the case.
That's correct, but also that, did you hear what the plea offer itself was, what the state has offered you at this point?
I did not hear that. No, sir.
All right. Ms. McNeil, would you just place that on the record real quick, please?
Yes, the offer in this case is plea to the charge. Then the state would make no specific recommendation at sentencing. The offer is open to further negotiations. It is conditioned on the defendant complying with the terms of his bond, and it expires at the judicial pretrial.
All right. Now, Mr. Berman, that was a correct recitation again, correct?
Yes, that's.
All right, thank you. Did you hear it now, Mr. Winkles?
So there's no, just so I'm under the understanding, there is no exact sentencing term. It's just for me to plea to the offense of the count one of the delivery of the methamphetamines.
Well, I have to let you talk to Mr. Berman. Mr. Berman, you're going to need to talk additionally with Mr. Winkles?
Yeah, Judge, Commissioner, maybe we should go into a breakout room.
Okay, we'll do that.
Thank you.
Okay,
Thank you.
again, I do want to just say, if I take you out of that breakout room suddenly, I'll put you back in it, okay?
Okay.
Thank you, I appreciate it.
Good morning.
Madam Clerk, I'm not in the breakout room.
On the bottom box with the 4 squares.
Oh,
Okay.
all right.
Just one moment.
Take your time.
Let me know when you're ready. Okay. All right, we'll go back on the record. State of Wisconsin versus Tony A. Winkles, 20 CF 615. Appearances remain the same. Mr. Berman?
Thank you, Commissioner, for giving us that opportunity to go in the breakout room. I did speak with Mr. Winkles regarding the offer that was made to waive the prelim. I believe he now understands what that offer encompasses, and he's ready to proceed with your colloquy.
All right, thank you very much, Mr. Berman. Mr. Winkles, did you just hear what Mr. Berman just indicated?
Yes, Your Honor.
Is that accurate, sir?
That's absolutely accurate.
Okay.
Your Honor.
So now you had enough time to discuss that offer and its potential impact on you with Mr. Berman, is that correct?
Yes, Your Honor.
Did you also have enough time to discuss with Mr. Berman the waiver of the preliminary hearing today and the impact that'll have?
Yes, Your Honor.
All right. And again, any questions that you might have had regarding both the plea offer and the waiver of the preliminary hearing, were the answer to your satisfaction?
Yes, Your Honor.
All right. Now, just a few more questions for you, Mr. Winkles. You understand that you did have a right to have the preliminary hearing held today if you'd wanted it to be held.
Yes, Your Honor, I am.
Also, you also have the right to waive the preliminary hearing, which is what I understand you wish to do today. Is that correct?
Yes, Your Honor, it is.
All right. Now, you understand that a preliminary hearing is not a trial. It's one step in your case proceedings.
Yes, Your Honor.
But when you waive your right to the preliminary hearing, and once the hearing's been waived, that's a permanent waiver. And that what that means is that once the hearing's been waived, may not come back before this court or any other court seeking to have another preliminary hearing. Do you understand that?
I do, Your Honor.
But even though you're waiving your right to the preliminary hearing today, sir, you still have a right to have a trial in your case if you wish to have a trial. Do you understand that?
I do that, Your Honor.
Also today, when you waive your right to the preliminary hearing, this court today will make a finding in your case that probable cause exists that a felony was committed and further probable cause exists to believe that you committed that felony. This court will then bind your case over before the Circuit Court of Kenosha County for further proceedings. Do you understand that?
I do, Your Honor.
You understand everything I've just explained to you, questioned you about, or discussed with you?
Yes, sir, Your Honor, I do.
You have any questions for me?
No questions, Your Honor.
All right, Mr. Winkles, if you have a question, you make sure you ask it. Don't feel like you can't ask me a question, okay?
I will, Your Honor. Thank you.
All right, you're welcome. Okay, now, other than that plea offer that was placed on the record, is there any other offer at this point that you've received that I'm not aware of?
No, Your Honor.
Did anyone threaten, force, or coerce you, Mr. Winkles, to get you to waive your right to the preliminary hearing?
No, Your Honor, they did
All
not.
right. And Mr. Berman, did you discuss the waiver document with Mr. Winkles?
Yes, Commissioner, I discussed both your court form waiver of right to preliminary hearing as well as the waiver the preliminary hearing waiver plea offer form that is generated by the district attorney's office.
Okay, thank you. Mr. Winkles, you remember reviewing a form that was, the title was waiver of right to preliminary hearing, in which it had a series of questions to be answered on the form by you and Mr. Berman? Do you remember that?
I believe I do, Your Honor.
Okay. Were the answers that you provided all true and accurate in their entirety?
Yes, Your Honor.
Okay. Any questions for me about the document?
No, Your Honor.
And did Mr. Berman answer every question you might have had regarding that document?
Yes, Your Honor.
Okay. All right, thank you.
Commissioner, if I can just interject, just to be clear, Mr. Winkles never saw the documents, but I read them to him.
Right, that's what I would assume, that
Okay.
you haven't looked at the document. You discussed those
Yes.
questions and those answers on the document with Mr. Berman, correct?
Yes, Your Honor.
All right. Now, did anyone threaten, force, or coerce you, sir, to get you to waive your right to the preliminary hearing?
No, Your Honor.
All right, thank you. Mr. Winkles, are you asking this court then to accept your waiver of the preliminary hearing today?
Yes, Your Honor.
Thank you very much, sir. Mr. Berman,
you.
any reason why the court should not accept the waiver?
No, Commissioner, there is not.
Thank you. Ms. McNeil?
No reason.
Thank you. The court then finds that Mr. Winkles, the defendant, has freely, voluntarily, knowingly, and with the advice of competent counsel, waived the defendant's right to the preliminary hearing. The waiver is accepted. Court does find in this case that probable cause exists that a felony was committed, and further probable cause exists to believe that this defendant, Mr. Winkles, committed that felony. Therefore, this matter is bound over before the Kenosha County Circuit Court. Further proceedings before the, at this point, the Honorable Bruce E. Schrader. Mr. Berman, I do have an information which has been filed. So
Thank
we,
you.
may, yeah, go ahead, sir.
I would acknowledge receipt of the information, waive its reading. The charge mirrors that in the criminal complaint. So Mr. Winkles is aware of that charge and the maximum penalty. To that, I would enter a plea of not guilty, preserving jurisdictional objections, and ask that the matter be placed on the court's trial.
All right, thank you. We've moved to arraignment. A not guilty plea has been entered for the record, received and entered for the record on behalf of Mr. Winkles. And the matter will now be counted before the Honorable Bruce E. Schrader for further proceedings.
Okay, the date for the pretrial conference with Judge Schrader is going to be July 22nd at 10:30.
Will that be in person or via Zoom?
Probably in person.
Then I would not be available at 10:30. I could do
1:30.
11 o'clock.
July
11.
22nd at 1:30.
Can we do 2 o'clock? I've got a 1:30 in a different branch.
Could you do July 23rd at 1:30?
That would work. Thank you.
Okay, to go with that, jury selection is August 10th at 9 o'clock.
That's fine.
All righty. Then I do see that a notice of motion and motion to modify bond has been filed on behalf of Mr. Winkles by his attorney, Mr. Berman. Ms. McNeil, has the state received a copy of the motion?
Yes,
Is it prepared to address the issues in the motion?
yes.
All right, then, Mr. Berman, is there anything further? I read your motion to modify bond. Would you like to add anything to that?
No, Commissioner, I believe my motion is sufficient on its face. Mr. Winkles is asking that the court modify the bond from $2,000 cash to a like signature bond, please.
All right, thank you. Ms. McNeil?
The state does not object to a modification. However, the state believes that $500 cash would be the appropriate amount to secure the defendant's appearance and compliance with the conditions of bond.
All right, thank you. Yeah, I mean, for the reasons I stated before, there was a cash bond. I still believe a cash bond is reasonable and necessary to assure the defendant's appearance in court, but I'll modify that bond to $500 cash at this point. Do you understand, Mr. Winkle?
Yes, Your Honor. Your Honor, is there any possible way of getting any, I don't know if this court would be able to do so, but I've been having trouble getting in touch with people to make bond as far as accepting collect calls. Would there be a possibility of getting maybe 2-3 phone calls that are not collect so I could possibly procure that bond to bond out?
I understand the question. I don't have any authority to order the sheriff's department to do something like that, sir. So you might want to take it up with Mr. Berman to see if some arrangements or give some numbers to Mr. Berman, perhaps to talk or to call. I'll leave it between you two, but I don't have authority to order the sheriff's department to allow you to make calls somewhere, especially if they're long distance calls. Okay.
Yes, Your Honor. If it does make any difference, Your Honor, also I have procured an address in Kenosha to stay at to make sure that I can show up to my court dates. As a matter of fact, I have a couple. My mother lives in Antioch with my grandmother. My brother lives in Kenosha. And I have a friend of mine that stays in Twin Lakes, Wisconsin, that has offered for me to be able to stay with him during these court proceedings.
Okay, that's, yeah, again, something that you might want to discuss with Mr. Berman, Mr. Winkles, just so, you know, that he's aware of what's going on. He can further assist you in your case, okay?
Okay, Your Honor, thank you so much.
Thank you, sir.
Thank you.
Thank
very
you,
much.
Commissioner.
Thank you, Mr. Berman. Okay.
Okay, Mr. Jones will be next. You can still
Okay.
hear us, Mr. Jones?
Yes, yes.
Thank you.
All righty. Okay.
Echoing a bit, but I can hear.
It'll be just a minute, Mr. Jones. Just have
Okay.
to take care of some, what we call housekeeping business here. Good morning, Miss Edwards. Do you need to speak with Mr. Rojas? Except Mr. Rojas isn't in custody, is he?
He's not.
Okay. Do you need to speak with him when he's admitted or no?
No,
Okay, thank you. It'll be just a few moments.
that's absolutely fine. Thank you so much.
Thank you.
All right, I will call the matter of the state of Wisconsin versus Bryant L. Jones, 20 CF 21. Appearances, please.
The state appears by Carly McNeil.
Attorney Mike Barth appears on behalf of Mr. Jones. I am appearing by Zoom. Mr. Jones is appearing by phone. At this point, he does object to the Zoom hearing. He indicates that his phone is not capable of getting video, as well as he is having problems with the audio. So I would request an in-person hearing. I am waiving any and all time limits. Mr. Jones is not in custody at this time.
All right, so if I understand that, Mr. Jones, if you can hear me, this is the commissioner. Are you able to hear me, sir?
Yes, I can, sir.
All right, and you wish to have an in-person hearing, is that correct, sir?
Correct, because like,
All right, okay, then you understand then your attorney said you're willing to waive time limits so that we may calendar your preliminary hearing out beyond the 20-day statutory limit from your initial appearance. Is that correct?
yes.
All right, then based on representation of Mr. Barth and discussion held with Mr. Jones, wherein Mr. Jones is willing to waive time, understanding the issues involved, the court will find that that was a intelligent, knowing waiver. This matter will now be calendared outside, and court will toll time for cause, calendar the matter outside of 20-day statutory limit.
Okay, coming back here for a preliminary hearing, July 22nd
Okay.
I'm
at
sorry.
9:30.
I'm not
9:30,
available
okay.
that morning. I have an eye appointment because I have glaucoma. I have to take this.
July 23rd at 9:30.
I can't do it that day. Could we do it the 24th?
Sure.
Anytime?
9:30.
Perfect. I'm anxious to see everyone again.
Okay,
All right,
us too. All right, July 24th at 9:30. Just a reminder, please wear a mask when you appear for court.
Okay, now is this in the intake building still, right?
Correct, yes.
Okay, okay, alrighty. 24th
Okay.
at 9:30, alrighty.
All right, thank you,
On the
everyone.
24th. Thank you. You're free to disconnect.
All right, thank you.
Bye-bye. Okay. That's weird.
For the person who just joined, if you could connect to audio, please. Hello, can I have your name, please?
Hello, Francisco Rojas.
Okay, thank you. And your attorney is with us on Zoom also, Francisco?
Okay.
All righty. Morning, everyone. I will call the matter of the state of Wisconsin versus Francisco Rojas, 20 CF 593. Appearances, please.
The state appears by Carly McNeil.
Francisco Rojas appears by video conference, as does his attorney, Hillary Edwards.
All right, thank you, Ms. Edwards. This matter is counted for preliminary hearing. Will this be a hearing or a waiver?
It's a waiver, Your Honor. I filed all the appropriate paperwork yesterday.
Oh, all right, great. Let me pull it up then, okay? I also saw you filed a waiver as well, Ms. Edwards, so I'll address that in just a minute. All righty, thank you. Ms. McNeil, would you just place the offer on the record, please? I see it was filed, but would you place it on the record?
The offer is to plead to count 1, dismiss the remaining, and the state would make no specific recommendation at sentencing. The offer is open to further negotiations. It's conditioned on the defendant complying with the terms of his bond. It expires at the first judicial pretrial, and the state is in victim legislation compliance.
All right, great. Thank you very much. Ms. Edwards, was that a correct recitation of the offer?
Yes.
And did you have enough time to discuss the offer as well as its potential impact with Mr. Rojas?
Yes.
Did you also have enough time to discuss, Mr. Rojas, the waiver of the preliminary hearing and the impact on his case that will have?
Yes.
All right, thank you. Mr. Rojas, good morning, sir.
Good morning.
Now, sir, I just have a few questions for you. First off, did you just hear the plea offer that was placed on the record?
Yes.
That same plea offer you understood you received?
Yes.
All right. Now, again, you can hear me okay at this point, sir. Is that correct?
Yes, I can.
All right. And you could hear the other attorneys talking as well,
Yes.
correct? All right. And are you thinking clearly today, sir?
Yes, I am.
All right. Now, did you have enough time to discuss that plea offer as well as its potential impact upon you with your attorney, Ms. Edwards?
Yes, but I just want to waive the court hearing.
No, I understand that. I just have to ask you a series of questions about that, though, okay? Just to confirm
right.
that, okay?
Yes.
All right. And also, did you have enough time again then to discuss the waiver of the preliminary hearing with Ms. Edwards?
Yes.
All right. And in regards to both the plea offer and the waiver of the preliminary hearing, did Ms. Edwards answer any and all questions you might have had?
Yes.
Okay. Now, just a few more questions, sir. Do you understand that you did have a right to have the hearing held, though, if you'd wanted the hearing to be held? You understand that?
Yes.
Okay, but you also have the right to waive the hearing, and that's what, again, I understand you wish to do. Is that correct?
Yes.
Now, you understand that a preliminary hearing is not a trial. It's one step in your case proceedings?
Yes.
And when you do waive your right to the preliminary hearing, though, that's a permanent waiver. And what that means is that once the hearing's been waived, you may not come back before this court or any other court seeking to have another preliminary hearing. You understand that?
Yes.
But even though you're waiving your right to the preliminary hearing today, Mr. Rojas, you understand that you still have a right to have a trial in your case if you wish to have a trial.
Yes.
And also today, when you waive your right to the preliminary hearing, this court will make a finding in your case that probable cause exists that a felony was committed and further probable cause exists to believe that you committed that felony. This court will then bind your case over for further case proceedings before the Circuit Court of Kenosha County. You understand that?
Yes.
Okay. I also see there's a document here entitled Waiver of Right to Preliminary Hearing. Now, I assume you and Ms. Edwards discussed that document electronically. Is that correct?
Yes.
All right.
Like the phone.
Over the phone. Okay. And then there are questions on that document that were required to be answered. And do you remember answering those questions on the document?
Yes.
Okay. And did you have enough time to discuss that document with Ms. Edwards?
Yes.
And are all the questions on there true and accurate in their entirety that are answered?
Yes.
All right. Any questions for me about that document?
No.
Okay. All righty. Thanks. Now, just a few more questions. Well, let me ask you to begin with. Do you understand everything I've just explained to you, questioned you about, or discussed with you?
Yes.
Okay. Do you have any questions for me at this point?
I do not.
All right, Mr. Rojas, if you do have some questions or a question, make sure you ask me. Don't feel like you can't ask me a question, okay?
Okay, I appreciate it.
All right, sure. Now, other than the plea offer that was placed on the record, is there any other offer you were given that I'm not aware of, sir?
No.
All right. Did anyone threaten, force, or coerce you, sir, to get you to waive your right to the preliminary hearing?
No.
All right, Mr. Rojas, are you asking this court then to accept your waiver of the preliminary hearing today?
Yes.
All right, thank you very much, sir. All right, Ms. Edwards, any reason why the court should not accept the waiver?
No.
All right, thank you, Ms. McNeil.
No reason.
All right, thank you. Court then finds that Mr. Rojas, the defendant, has freely, voluntarily, knowingly, and with the advice of competent counsel, waived the defendant's right to the preliminary hearing. The waiver is accepted. The court does find in this case that probable cause exists that a felony was committed, and further probable cause exists to believe that this defendant committed that felony. Therefore, this matter is bound over before the Kenosha County Circuit Court for further proceedings. Now, there has been a substitution of judge filed. That substitution was in its proper form and was timely filed. This matter had originally been calendared before the Honorable Bruce E. Schrader. With the substitution, now this matter will be calendared before the Honorable Jason A. Russell for further proceedings, including arraignment, as Judge Russell will conduct his own arraignment. Nonetheless, I do have an information which has been filed. And Ms. Edwards, do you acknowledge receipt of a copy of the information?
I do. I would waive its reading and enter. Well, I would wait to enter pleas for arraignment.
All right, thank you very much. And as I said before, the matter will now be counted for arraignment before Judge Russell. And Mr. Rojas, just so you're aware, sir, any and all previously imposed bond conditions in your case remain in full force and effect at this time, okay?
Okay.
Thank you, sir. Thank you.
Okay, arraignment with Judge Rosell on August 21st at 8:30. Ms. Edwards?
That works. Thank you.
Okay, again, that's August 21st, 8:30 with Judge Rosell.
Thank you.
Thank you. That concludes this hearing. Mr. Rojas, you're free to disconnect now.
Thank you.
I have Mr. Mendoza who is in custody.
Do you need to speak with him?
I do. No offer was tendered, so I haven't spoken with him about waiver.
Okay. I'll send you to a breakout room.
Thank you.
Good morning, Steve.
Hello, how are you?
Good, thank you. Which case are you for?
John Mendoza?
Okay, it'll be just a few minutes.
Okay,
He's talking to him now, his attorney.
got it.
Ms. Edwards, will this be a hearing or a waiver? Oh, you're on mute, sorry.
It's going to be a request for an adjournment. Mr. Mendoza has not been receiving his medication for his mental health issues, and he does not believe he's thinking clearly today.
Okay.
Okay. You ready, Laura?
Yeah.
Okay. All right, I will call the matter of the state of Wisconsin versus John G. Mendoza, 19 CF 476. Appearances, please.
The state appears by Carly McNeil.
Is Mr. Mendoza out there?
I have a man in front of me here with a mask.
Oh, there he is. Okay, I didn't see him. I apologize. John Mendoza appears in person and by video conference by his attorney, Hillary Edwards.
All right, good morning. Sir, are you John G. Mendoza?
Yes.
All right, thank you, sir. Okay, Ms. Edwards, this matter's on for preliminary hearing.
Yes, Your Honor. We are asking for an adjournment. Mr. Mendoza does suffer from medical issues that affect his ability to understand and work through the waiver documentation or the understanding of a preliminary hearing. I understand that Crisis is working on getting him his proper medications. However, they have not done so yet. We are asking for an adjournment to address that issue. He is on a probation hold at this time, but both he and I want to make certain that he understands what he is doing before we either proceed or waive.
All right, so as there, at least at this point, I understand that Mr. Mendoza is on a hold, but is he willing to, at least at this point, waive time to have the hearing set out beyond the statutory limit?
He did say so, but I think there would be cause regardless because of his lack of ability to understand paperwork or the hearing.
Okay, great, thanks. Ms. Edwards, you need me to do a colloquy or conduct a colloquy with Mr. Mendoza, or simply just?
I believe it would be appropriate for cause regardless. Based
Okay,
on my
then
presentations.
that's fine. Then I'll just, I'll go off of your representation. All right, and I'll told time for cause based on representations set forth by Ms. Edwards on behalf of Mr. Mendoza. And we'll have this matter recalendared for preliminary hearing. Do you want to put it on for a status first, or would you rather put it on for a preliminary hearing then, Ms. Edwards?
I think preliminary hearing, I understand that he has a meeting with Crisis today. And since he's been in custody for a week or so, I think that they're usually pretty quick about getting that in order.
Okay, how long do you want to go out for then?
2 weeks?
2 weeks? Okay, all right, thanks.
July the 15th at 9:45.
Yeah, I can make that work.
Great, thank you very much. That
All right.
concludes this hearing.
Thank you.
Thank you, Mr. Mendoza.
Okay. I also have a 9:45 in custody that I would need a breakout room for.
Okay, I'll let them know.
Thank you.
I go back to that room. Good morning, Mr. Jones.
Good morning.
It's obviously 9:30. Your person's still never logged in.
Okay. Outstanding. I do have a motion hearing in branch 6, and now that's running a little bit behind, but it is scheduled for now. And I appreciate the court's patience. I know I've been in branch 6 all morning.
That's okay, Mr. Jones. I'll call your case and we'll just, we'll deal with it and then we'll go for it, okay?
Okay,
That way,
thank you.
that way you can take off at this point. Is this your only case before us today?
It is, yes.
Okay, yeah, let's just call it. I'll call State of Wisconsin versus Tariq T. Sloan. So 20 CF 334 appearances, please.
The state appears by Carly McNeil.
Counsel Matthew Jones appears on behalf of Tariq Sloan.
All right, thank you. Mr. Jones, you're aware Mr. Sloan's not in appearance at this point. Do you know why that may be?
I have no information to offer the court, Your Honor. I would note that he has made his other appointments, including a competency evaluation and his competency hearing previously.
Okay, well, oh, good. I'm sorry. I don't mean to cut you off.
My concern is that maybe I have incorrect contact information for Mr. Sloan, and that I'm sure the court provided evidence, provided notice, but I'm not 100% sure that he knew there was the hearing today.
Well, do you want me to, I'm inclined to issue a bench warrant at this point, but I can stay until 1 o'clock if you can get a hold of him.
I would appreciate that.
How about that? Okay. All right. Well, I believe there was a $1,500 cash bail that had been posted. It looks like on June 1st, perhaps.
Right.
All right. Based on the non-appearance after having been given notice, let me look on the bail bond.
And this
We'll
was a
check the lobby, yeah.
This was a unique case in that there was the competency evaluation set before the preliminary hearing. So we set this date in branch 2.
Oh, okay.
And I'm not sure if this might have been one where Madam Clerk in branch 2 had contacted me after the hearing to set this preliminary hearing time. So I'm not sure that we had set the prelim time during the competency evaluation. I think that was set afterwards.
Okay. And there's I know a new address listed here too. Well, I'll tell you what I'll do. Assuming that Mr. Sloan is not out in the lobby here, I'm not going to take a position yet with the forfeiture of the bond. There's $1,500 posted, but I will issue a $1,500 bench warrant. But I'll stay that until 1 o'clock today. If you can also get a hold of him and make it by 1, that's great. If not, then perhaps, calendar for a voluntary.
Understood, Your Honor.
Okay, all right.
So if you can get a hold of him, I'll send you the Zoom code for 1 o'clock today, okay?
I'll be there anyway, but thank you.
Okay, thanks. Yeah, Mr. Sloan was not out in the lobby, just so you.
I appreciate that, and I appreciate the court's patience.
No problem, Mr. Jones. All right, thank you very much.
Thank you.
Bye-bye.
Good morning, Attorney Ward. Yes, instead of Mr. Barth. And I did notify Mr. Barth this morning. Good morning, Alberto. Sorry, you're on mute. I don't have any of the simultaneous stuff set up because I haven't really researched how it works after being gone for a few weeks. So we're just going to do this the regular way.
Consecutive, okay.
Okay. Mr. Ward, Mr. Ramirez is with you, correct? I see someone's forehead next to you. Hi, Mr. Ward. You're on mute still, just so you know. Mr. Ramirez is with you?
Yes.
Okay. And I have Mr. Aguilar to interpret today. Is this a hearing or a waiver?
At this point, it's a hearing.
Okay. And you have three traffic citations that go with this, the three numbers.
There's 3 traffic citations. I believe there's 2 criminal traffic files that are trailing as well.
And today we're only here on the 20 CF 531 and the 3 traffics, 30, 56, 57, and 58.
Okay.
Okay, thank you. Are you ready, Ms. McNeil?
Yes, I am. I'm just wondering if the
It says-
KSD officer is there.
KSD down there. There's Deputy Cott.
All right.
All right, everyone. First off, Mr. Aguilar, have you been sworn in yet?
No, Your Honor.
All right, would you raise your right hand, please, sir? You solemnly swear to interpret the English language into the Spanish language and the Spanish language into the English language, so help you.
I do. Certified Spanish interpreter Alberto Aguilar.
Thank you,
Intérprete
sir.
juramentado.
I will now call the matter of the state of Wisconsin versus Jose L. Ramirez Jr., 20 CF 531.
Ahora voy a llamar el caso del estado de Wisconsin versus José L. Ramírez, caso 20CF531.
I'm also calling Kenosha County versus Jose L. Ramirez Jr., and I have 3 files.
También voy a llamar 3 casos el caso de el condado de Kenosha en contra de José Ramírez Jr.
20 TR 3056,
20 TR 3056,
3057,
3057
and 3058.
y 3058.
May I have the appearances, please?
¿Quiénes comparecen, por favor?
The state and county appear by Carly McNeil.
El estado y el condado comparecen a nombre de Carly McNeil.
Good morning, Your Honor. Please, the court, Mr. Ramirez appears with Attorney John Anthony Ward via Zoom.
Sí, su señoría, entonces el señor Ramírez comparece con su abogado, el señor John Anthony Ward, vía Zoom.
Mr. Ward, any objection regarding the appearance by Zoom?
Señor
No
Ward,
objection
¿alguna
regarding-
objeción en relación a la comparecencia por video Zoom?
No objection to appearing by Zoom. I will inform you, Commissioner, that as I need to take notes through my computer, I may be off screen on occasion. But that way the screen can be focused on my client.
No hay ninguna objeción para comparecer por video Zoom, pero le dejo notar de que de vez en cuando mi computadora va a ponerse en blanco, pero voy a poner a mi cliente en la pantalla.
Understood, Mr. Ward.
Entendido, señor Ward.
I'm going to make a finding for this case, the previous cases, and the future cases to be held this morning in this courtroom via Zoom, that good cause exists to hold these hearings via the Zoom application.
Voy a declarar que existe buena causa para tener estas audiencias por medio de video Zoom, para este caso, los casos anteriores y cualquier caso futuro.
Based upon the coronavirus pandemic and orders entered by the Supreme Court of the state of Wisconsin and the Circuit Court for Kenosha County.
Basado en la pandemia que estamos enfrentando, tanto como las reglas que han puesto la Corte Suprema de este estado y los tribunales.
Further, absent any objection raised to having the hearing held via the Zoom application by either defendants, defendants counsel, or both.
También debido a que ninguna persona está en contra de esta forma de comunicación, ya sea los abogados o la fiscalía o nosotros.
That having been said, this matter is on for preliminary hearing in the felony file.
Este caso está entonces puesto para una audiencia preliminar, en este caso de audiencia para un caso mayor.
Mr. Ward, as to the preliminary hearing?
Señor Ward, entonces en relación a la audiencia preliminar.
Well, we're ready.
Estamos listos.
Ms. McNeil, has there been an offer tendered?
Señora McNeil, ¿ha habido alguna propuesta que se ha dado?
So I do see an offer. It is not clear to me whether Mr. Ward has seen it because he was not the counsel of record previously.
Veo una
I've
propuesta,
seen no
pero no
offer.
sé si es que el señor Ward lo ha visto, puesto de que él no era el abogado puesto en este caso anteriormente.
Mr. Ward, would it assist you if Ms. McNeil could email you at this point that offer so you could discuss it with your client or not?
Señor Ward, ¿usted está bien que la señora McNeil le envía a usted esta propuesta por correo electrónico para que usted lo revise con su cliente?
I have no objection to her emailing it, but also if she'd state it on the record, I can go on mute for a couple of minutes and discuss it with my client.
No tengo ninguna objeción, pero como ella ha dicho, entonces yo pido que se me ponga en mudo para hablar con mi cliente por un momento sobre esto.
Thank you, Mr. Ward. Ms. McNeil, would you be in a position to first off email that to Mr. Ward and secondly, place the offer on the record?
Gracias, señor Ward. Entonces, señora McNeil, ¿usted estaría dispuesto a enviarle por correo electrónico al señor Ward esta propuesta y también para ponerlo aquí en el acta?
Yes, I'm emailing it right now.
Lo estoy mandando ahora mismo.
And for the record, the offer is plead to counts 1, 2, 3, 5, and 6. The state would dismiss counts 4 and 7 and recommend prison, free on length and free on conditions. The defendant would have to stipulate to any restitution or costs. The offer would expire at the judicial pretrial, and the state is in victim legislation compliance.
Entonces, la propuesta sería de que si él se declara al cargo 1, 2, 3, 5 y 6, entonces retirar el cargo 4 y 7. También recomendaríamos prisión de ningún tiempo determinado y con condiciones. También, si es que el acusado se haría a cargo de los costos y también se ha cumplido con todas las personas involucradas en este caso en relación a víctimas y personas afectadas.
All right, Mr. Ward, did you receive the emailed offer?
Señor Ward, ¿usted ha recibido la propuesta por email?
I've not yet received the email, Commissioner, but I heard the offer as recited orally on the record.
No he recibido todavía la propuesta por email, pero sí he escuchado la propuesta que se ha dado oralmente aquí.
I will discuss it with my client.
Voy a hablar de esto con mi cliente. Bien.
One warrant and one new charge. Yes, yes. So, and I believe we have the pre-signed waiver.
Okay, we're prepared to proceed, Commissioner.
Muy bien, estamos preparados para continuar, comisionado.
Yeah. I think he has everything.
All right, Mr. Ward, you indicated that you're prepared to continue with the hearing. Is that correct?
Muy bien, señor Ward, usted ha dicho de que usted está preparado para continuar con esta audiencia. Sí, eso es correcto.
Did you have enough time to discuss the offer received from the state with your client?
¿Ha tenido suficiente tiempo para hablar sobre la propuesta que la Fiscalía le ha enviado con su cliente? Sí.
And your client's rejecting the offer?
¿Y su cliente está rechazando la propuesta?
That is correct.
Eso es correcto.
Ms. McNeil, the state's position with respect to the hearing going forward?
Y señor McNeil, entonces, ¿cuál es su postura sobre el caso de aquí en adelante?
The state is prepared to proceed.
El Estado está preparado para proceder.
In terms of, is there any issue with respect to future, the offer itself and future offers or negotiations?
En términos de la propuesta y futuras negociaciones, ¿cuál es su postura?
The state is not required to give any further offer, and that will be up to the prosecutor who is assigned to the case in the end.
El Estado no está obligado a dar ninguna otra propuesta futura y esto está ahora en las manos del procurador que va a tomar el caso de aquí en adelante.
All right, Mr. Ward, I just have two questions.
Señor Ward, tengo dos preguntas.
One, does your client understand the state has no further obligation if it chooses to not tender a new offer, the same offer again, or further negotiate?
Ahora su cliente entiende de que la fiscalía no tiene ninguna obligación de darle a él ninguna otra propuesta o alguna negociación de aquí en adelante.
My client understands that he has no obligation to negotiate whatsoever.
Mi cliente entiende de que la fiscalía no tiene ninguna obligación para negociar en lo absoluto.
My second question is that you held a discussion with your client without the use of Mr. Aguilar. Were you able to communicate with your client despite not using Mr. Aguilar at that point?
Mi segunda pregunta es que usted habló con su cliente sin la ayuda del intérprete del señor Aguilar y solamente quería preguntar si es que ustedes han tenido esa conversación y si la han entendido.
He has two family members here who speak fluent English, Your Honor, as well, that are not on camera, that were also able to render assistance if he didn't understand something.
Su señoría, él tiene dos parientes aquí presentes que hablan el inglés al 100%, pero no están mostrados en cámara.
And I'm able to relay the choices in very simple English, so it wasn't too difficult.
Y también yo le pude hablar sobre las cosas que tenía que elegir en términos simples.
All right, as you could imagine, I wanted to place that information on the record.
Como puede imaginar, yo tenía que poner eso en el acta aquí.
Now, I have some questions directly for Mr. Ramirez, if I may.
Ahora, yo tengo algunas preguntas directamente al señor Ramírez, si se puede.
Mr. Ramirez, this is the commissioner. Are you able to hear me, sir?
Sí, señor Ramírez, le habla el comisionado. ¿Usted me puede escuchar?
Yes.
Yes.
And did you hear the plea offer that was given to you by the state?
¿Usted escuchó cuál era la propuesta que la fiscalía le dio a usted?
Sí.
Yes.
Did you understand that plea offer?
¿Usted entendió esa propuesta de la fiscalía?
Sí.
Yes.
And did you have enough time to discuss that plea offer as well as its potential impact upon you with your attorney, Mr. Ward?
¿Y usted tuvo suficiente tiempo para hablar sobre esa propuesta de la fiscalía, tanto como el impacto que tendría esto en su caso con el señor Ward?
Sí.
Yes.
And are you thinking clearly today?
¿Está pensando de manera clara hoy?
Sí.
Yes.
And did Mr. Ward answer any and every question that you might have had regarding that plea offer to your satisfaction, sir?
Y el señor Ward le ha contestado cualquier pregunta que usted habría tenido sobre esa propuesta a su conformidad?
Sí.
Yes.
Do you have any questions for me, the court commissioner, at this time about the plea offer or its potential impact? I'll leave that to Mr. Ward, but about that plea offer to me.
¿Usted tiene alguna pregunta para mí como comisionado sobre la propuesta de la fiscalía, tanto como el impacto? Bueno, eso lo voy a dejar a su abogado, señor Ward, pero ¿usted tiene alguna pregunta sobre la propuesta?
No.
No.
And sir, is it you're wishing to reject the plea offer at this point and have the hearing held today? Is that correct?
Y señor, usted está rechazando la propuesta que le acaba de dar la fiscalía y usted quiere proceder en su caso hoy. ¿Es eso correcto?
Sí.
Yes.
And you understand now that the state has no further obligation, if you have this hearing held, to offer you another plea offer or to further negotiate with you and Mr. Ward.
Ahora, ¿entiende usted que la fiscalía no tiene ninguna obligación de darle algún tipo de negociación o alguna otra propuesta de aquí en adelante? ¿Usted entiende eso?
Yeah, they'll be.
¿Cómo? Yes.
And that, and this would only occur if a conviction occurs in this case. But if a conviction occurs, the state could request the maximum penalty be imposed for any conviction at the time of sentencing.
Ok, y esto ocurriría solamente si hubiera una condena. Si a usted se le condenara de estos delitos, entonces la fiscalía estaría buscando la pena máxima en contra suya. ¿Usted entiende eso? Yes.
All right, thank you very much, Mr. Ramirez.
Muchas gracias, señor Ramírez.
Now, the state is prepared to proceed, correct?
Ahora, la fiscalía está dispuesta a proceder, ¿no? Sí.
How many witnesses for the state?
¿Cuántos testigos tiene la fiscalía?
One witness.
Un testigo.
Mr. Ward, for the defense, how many witnesses?
Señor Ward, para la defensa, ¿cuántos testigos? Ninguno.
All right, the defense is prepared to proceed, correct?
¿La defensa está preparada para proceder? Sí.
All right, Ms. McNeil, you may call your first witness.
Señora McNeil, por favor, llame a su primer testigo.
The state calls Deputy Gott.
La fiscalía llama al policía Gott.
Deputy Gott, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Policía Gott, ¿usted jura decir toda la verdad y nada más que la verdad y lo jura por Dios? Sí.
Deputy, would you state your full name and spell your last name for the record?
Señor policía, por favor, diga su nombre completo y deletree su apellido para el acta.
Ryan Gott, G-O-T-T.
Ryan Gott, G-O-T-T.
Ms. McNeil, your witness.
Señor McNeil, su testigo.
Deputy Gott, how are you employed?
Policía Gott, ¿en dónde trabaja usted?
As a deputy sheriff with Kenosha County.
Trabajo en el condado de Kenosha como alguacil.
Were you on duty on May 17th of 2020?
¿Usted estuvo trabajando el 17 de mayo del 2020?
I was.
Sí.
And that, oh, sorry. That day, were you involved in an investigation of a crash that occurred in the 700 block of Sheridan Road?
Y ese día usted estuvo involucrado en la investigación de un accidente que ocurrió en la cuadra 700 de la Sheridan Road?
Yes.
Sí.
Is that location in the village of Summers, county of Kenosha, and state of Wisconsin?
Yes.
¿Esa localidad está en la villa de Summers, condado de Kenosha, estado de Wisconsin?
Yes.
Sí.
Also, have you reviewed a criminal complaint that was prepared in connection with this crash investigation?
¿También usted revisó una acusación que se preparó en conexión con ese accidente vehicular?
Yes.
Sí.
In terms of your involvement with this crash investigation, did you arrive at the scene of the crash?
En relación a su investigación de este accidente vehicular, ¿usted llegó a la escena del incidente?
Yes.
Sí.
At approximately what time?
¿Cómo a qué horas aproximadamente?
I don't know the exact time. I'd have to check the complaint.
No sé la hora exacta, yo tendría que revisar la acusación.
Was it during first shift hours?
¿Fue durante las horas del primer turno?
Yes, it was.
Sí.
When you arrived at the scene, what did you observe?
Cuando usted llegó a la escena, ¿qué es lo que encontró?
There was a silver Chevrolet in the middle of the road in the southbound lanes, directly in front of one of the entrances to the Villa Rosa apartments. It had heavy front end damage to it.
Había un Chevrolet plateado que estaba en medio de la carretera hacia el sur, enfrente de los apartamentos Villa Rosa.
Did you end up speaking to the occupants of this silver Chevy?
¿Usted habló con los ocupantes de este Chevrolet plateado?
Yes.
Sí.
And
did any of the occupants tell you what had occurred?
¿Y alguno de los ocupantes le dijeron qué ocurrió?
Yes, the driver, his name is Christopher Dodson. He said that he and his family were driving southbound on Sheridan Road when a blue SUV, he believed it came out of the Villarosa Apartments, pulled out in front of him, causing him to strike it.
Sí, un señor que se llama Chris Dodson decía que estaba viajando hacia el sur en la Sheridan Road y que él vio que un SUV azul vino y le despegó.
And did you also speak to a witness who had seen what occurred?
¿Y usted también habló con un testigo que había presenciado lo que ocurrió?
Yes.
Sí.
And what did the witness tell you?
¿Y qué es lo que le dijo el testigo?
I object to anonymous source statement about what an anonymous source said. There's no way to verify it. Part of the court's duty is to determine the reliability or potential reliability of any source. We should at least have their name.
Tenemos objeción a ese testigo sin nombre que está mencionando la fiscalía porque por ley la fiscalía debería nombrar a la persona que está siendo presentado como testigo. Estamos objecionando esto.
Ms. McNeil?
Señora McNeil.
I don't think it's accurate to characterize someone who has face-to-face contact with law enforcement as anonymous. I know that there is case law to that effect, that a person who is having that sort of face-to-face contact is usually not considered an anonymous witness.
Yo no creo que es bueno caracterizar a una persona que ha tenido una confrontación, o sea, una conversación cara a cara con un policía, porque esa persona, y lo dice la ley, no es una persona anónima.
I tend to agree with what you're saying, Ms. McNeil. However, Mr. Ward, I believe the question is more, is the at this point to this witness, the identity of that person known to this witness? Would that be accurate, Mr. Ward?
Entonces no estoy en desacuerdo con lo que dice usted, señora McNeil, sobre esto, pero la pregunta yo creo es para el señor Ward si es que solamente se conocía haber tenido contacto con este testigo.
Is the identity of a person known to this witness, Your Honor, but it is our position that your duty, Your Honor, is to make an independent determination. While hearsay is permitted, part of the being able to make an independent determination is to at least identify who is making statements. Accusations that the court may rely on in finding a fact. And the person at this point is anonymous to this court. And so how does the court make a determination whether the person has a connection, has a possible...
En relación a la identidad, sí es su deber, señor comisionado, es su deber suyo de dar una determinación independiente, porque nosotros estaríamos viendo a ver cuál es la ocupación de esa persona para, digamos, el tribunal pueda confiarse en lo que dice esta persona, ya que para nosotros es una persona anónima.
Well, at this point, go ahead, but at this point, if that's your argument, it's premature at this point because I don't know what first off, I don't know what the answer is. And secondly, I don't know if there's going to be follow-up questions with respect to why the deputy believed that that individual or individuals information was accurate or should be acted upon.
Bien, yo creo que esa entonces declaración es todavía prematura en ese caso, puesto de que no sabemos cuál va a ser la respuesta, cuáles son las preguntas que se van a hacer y cuáles van a ser las respuestas y también si va a haber alguna pregunta de seguimiento.
She asked what did this anonymous person have to say, Your Honor. At this point in time, it's my position, not premature. As a foundational matter, we should know who is talking and who's making these allegations.
Ella está preguntando sobre qué es lo que este testigo vio. Yo creo que eso es fundamental, que nosotros, porque le está preguntando qué es lo que vio y qué es lo que, o sea, ha presenciado.
She used the term witness, not anonymous person. That was your term, Mr. Ward. So again, I'm going to stand on what my ruling was and we'll let, I'm going to overrule for now. You may raise this objection again, but at this point, the court believes it's a bit premature. Ms. McNeil.
Ella sí dijo que era un testigo, no que era una persona anónima. Así que voy a dejar a que la fiscalía continúe con las preguntas. Señora McNeil.
Deputy Gott, did you identify this witness?
Policía Gott, ¿usted identificó a este testigo?
I did. took a written statement from him. I just don't recall what his name is at this point.
Sí, yo tomé una declaración por escrito de esta persona, pero no me acuerdo cuál haya sido su nombre.
And what did the witness tell you that the witness had observed?
¿Y qué es lo que le dijo el testigo que había presenciado?
The witness lives in the Villa Rosa apartments there. He has a back door that faces east, which is where the crash occurred on Sheridan Road. He said he was standing in his doorway and observed the crash occur.
Él dijo que él vive allí, que estaba viendo por una puerta trasera que está al este de la Sheridan Road, que él había presenciado ese choque.
He said that there was a blue SUV, a larger SUV. I don't know if he called it a Suburban or a Tahoe. But he said blue SUV was traveling northbound on Sheridan Road.
Él dijo que vio un SUV azul, no estaba seguro si era un Suburban o era un Tahoe, pero que estaba conduciéndose hacia el norte en la Sheridan Road.
And that blue SUV made a left turn, trying to turn into the Villa Rosa apartments, into the path of the silver Chevrolet.
Entonces ese SUV azul tomó una izquierda, viró hacia la izquierda, hacia los apartamentos de Villa Rosa, y es ahí cuando ocurrió el incidente.
And is that when the crash occurred?
¿Y ahí ocurrió el accidente vehicular?
Yes.
Sí.
When you spoke to Christopher Dotson, did he complain of any injuries?
Cuando usted habló con Christopher Dotson, él le dijo que había padecido algunas lesiones.
He complained of back and neck pain.
Él se estaba quejando de dolor de espalda y de cuello.
And in the car with Mr. Dotson, was his wife also present in the vehicle?
¿También estaba presente ahí la esposa de Chris Dotson ahí en el vehículo?
Yes.
Sí.
And was his wife identified as Regiana Dotson?
Su esposa fue identificada como Regiana Dotson.
Yes.
Sí.
Did she complain of any injuries?
¿Ella se quejó de alguna lesión?
Yes, she had a visible cut on her lip with blood on it, and she also complained of head and neck pain.
Ella tenía una cortadura visible en sus labios, y le estaba saliendo sangre de ahí, y también se estaba quejando de dolor en la espalda y el cuello.
Was she transported to the hospital?
¿La transportaron al hospital?
Yes.
Sí.
Now, this blue SUV that had been described as the other vehicle in the accident, was it on scene when you got there?
Y este SUV azul que fue descrito como el vehículo del accidente, ¿estaba ahí en la escena cuando usted llegó allá?
No.
No.
What information were you able to gather on where the blue SUV had gone?
¿Y qué información usted pudo recopilar de hacia a dónde se había ido ese SUV azul?
Mr. Dotson himself and the witness I talked about earlier and several other witnesses said that it fled southbound on Sheridan Road.
El señor Dotson, tanto como los otros testigos con quien hablamos, dijeron de que se había dirigido ese carro, ese SUV se había dirigido hacia el sur en la Sheridan Road.
So, according to the witnesses, including Mr. Dotson, the blue SUV did not stop at the scene of the crash?
De acuerdo a los testigos y también al señor Dotson, entonces el SUV azul no se había detenido ahí en la escena del accidente.
Correct, it left the scene.
Correcto, se huyó de la escena.
Shortly thereafter, was the suspect blue SUV located by law enforcement?
Poco tiempo después, la policía localizó al SUV azul.
I'm going to object, Your Honor, as an improper summary.
Voy a objecionar, su señoría, es un resumen completamente inadecuado.
Ms. McNeil?
Señor McNeil.
I thought I was just asking a question about whether the vehicle was found.
Pensé que solamente estaba preguntando si es que se localizó el vehículo, ¿no?
I'll go ahead, Mr. Ward. You want to expound
Adelante, señor
on
Ward.
your objection?
Sure. The the objection here, Your Honor, is that she says the suspect, which sort of implies that there was a suspect vehicle and that this was the vehicle. We've seen no evidence that would identify it other than a blue SUV. So I believe at this point it's an improper summary. It's also leading and suggestive.
Es indicativo, sugerido, porque está refiriéndose a este vehículo como el vehículo sospechoso cuando en realidad no se sabe qué vehículo fue. Simplemente estaba diciendo que es un SUV azul.
Ms. McNeil, why don't you reword the question, please?
Señor McNeil, por favor, dígalo de otra forma, esa pregunta.
Was a blue SUV located near the scene of this crash shortly thereafter?
Poco después se localizó al SUV azul cerca de la escena del accidente.
A blue SUV was reported to have crashed shortly after in the area of Carthage College.
Sí, se reportó de que un SUV azul se chocó justo cerca de donde estaba todo eso.
Did law enforcement respond to the location where this blue SUV had reportedly crashed?
Y la policía llegó a donde supuestamente este SUV azul se chocó.
Yes.
Sí.
And did law enforcement identify who had been the driver of the blue SUV?
¿Y la policía identificó al conductor de este SUV?
Yes, the driver was identified as Jose Ramirez.
Sí, el conductor fue identificado como José Ramírez.
And do you see Jose Ramirez? I'm going to ask if the defendant can remove his mask for a moment.
Voy a pedir que el acusado retire su mascarilla por un momento y le pregunta al policía, ¿usted ve al señor Ramírez?
Mr. Ward, if you could have your client remove the mask below his chin and then look directly into the camera, please.
Well, I'm going to object to this, Your Honor, at this point.
Close, he's
Por
gonna,
favor,
I'm
Your
sorry?
Honor, I'm objecting to the procedure. At this point, the officer has not provided any evidence that he's seen, known, or ever been involved with Jose Ramirez.
estoy objecionando todo esto porque el policía está diciendo esto, pero no hay nadie que haya identificado al señor Ramírez.
All right, Ms. McNeil, give us a little more foundation, if you will.
Ok, señora McNeil, por favor, déjanos un poquito más de fundamento, por favor.
Deputy Gott, did you review a booking photo of Jose Ramirez?
Policía Gat, ¿usted revisó una fotografía de la cárcel del señor Ramírez?
Yes.
Sí.
And was that booking photo of the Jose Ramirez that was arrested by law enforcement in connection with this case?
Y esa fotografía ahí que se tomó en la cárcel es una de José Ramírez que también fue, digamos, localizado en el accidente vehicular.
Yes.
Sí.
And were you able to see the person seated next to John Anthony Ward when he removed his face mask?
Well, hang on, I'm going to have that done again then, okay?
Voy a hacer que se vuelva a hacer esto.
Reserve that question. Mr. Ward, I would like you now to have Mr. Ramirez come closer to the camera and take his mask down, please.
Señor Ward, quiero que el señor Ramírez se acerque a la cámara y que se quite la
Remove
mascarilla,
his
por favor.
mask. There you go.
Bien.
All right, now you may ask the question, Ms.
Ok,
McNeil.
ahora sí puede hacer la pregunta, señor McNeil.
Okay, so based, Deputy Gott, on your ability to see the individual who has removed his mask, is that Jose Ramirez based on your review of?
No, just, excuse me, leave it down until I tell you to put it back
No, por
up.
favor, manténgalo quitado hasta que yo le diga que se lo vuelva a poner. I'm sorry, this is the interpreter speaking. Carly, could you please repeat your question?
So Deputy Gott, based upon seeing this person who is with Attorney Anthony Ward, having removed his mask, can you identify that person?
Policía Gat, basado ahora en la persona que estamos viendo aquí en la pantalla que se ha quitado la mascarilla, ¿usted puede reconocer a esta persona?
Yes, the subject next to Attorney Ward is Jose Ramirez.
Sí, la persona que está sentada al lado del abogado Ward es el señor José Ramírez.
And that's the Jose Ramirez that's subject to this hearing today and subject to the booking photo you reviewed. Is that correct, Deputy Gott?
Policía Gat, es el José Ramírez que está entonces en la foto que se tomó en la cárcel, tanto como la persona que está sentada aquí, ¿es cierto?
Yes, that is the same Jose Ramirez in the booking photo.
Sí, es el mismo José Ramírez que está en la fotografía que se tomó en la cárcel.
Okay, stand by 1 second, please. Okay, I have to check something. Sir, you may put your mask up.
Ya puede ponerse la mascarilla. Un momentito, por favor.
Ms. Edwards, could you go to branch 3, please? Thank you.
All right, you may
Thank
continue.
you. I will be
Well,
back as soon as I can be.
all right, I'm gonna make a finding that the record will reflect this witness has identified the defendant in this case.
Voy a declarar aquí en el acta que este testigo ha reconocido al acusado en este caso.
All right, you may
Deputy-
continue.
Continúe, por favor.
Deputy Gott, did the vehicle that the defendant was driving, did that vehicle have any damage to it?
Policía Gat, el vehículo que estaba conduciendo el acusado, ¿tenía algún tipo de daños en ese vehículo?
Yes, I believe it had damage on the rear passenger and driver side.
Sí, yo creo que tenía daños en la parte de atrás, tanto como el del conductor y del pasajero.
So based on the circumstances of the crash by the Villa Rosa apartments and the circumstances where the defendant's vehicle was found, did law enforcement suspect that he had been the driver of the blue
Objection, it's
SUV?
leading, Your Honor.
It is foundational to lead to what law enforcement did next.
Basado en las circunstancias de donde se encontró el vehículo, tanto en el hecho de que estaba
All right,
cerca...
Your
al-
screen froze, Ms. McNeil. If you could repeat that, the response to the objection, your screen froze and buffered for a second.
Su pantalla se congeló. Por favor, repita lo que acaba de decir.
So the response was that the question is foundational to explain what law enforcement did next.
La respuesta mía era de que las preguntas que yo hago era de fundamento a lo que la policía encontró.
Well, you can just simply ask, what did law enforcement do next? Whatever it was, a leading question. If you could rephrase, please.
Esa era una pregunta indicativa. Usted simplemente puede preguntar qué es lo que encontró la policía nada más.
After locating the defendant's crashed vehicle by Carthage College, what did law enforcement do next?
Después que usted encontró, que la policía encontró el vehículo cerca a Carthage College, ¿qué es lo que hicieron después?
Would object, the question assumes facts not in evidence at this point, and that there has been no testimony about where this accident occurred. Or where they
Objeción.
found the vehicle. The evidence on the record at this point, Your Honor, is that they found the vehicle near the scene.
I believe that.
Estoy
oh,
objecionando la pregunta a lo que se ha dicho, puesto de que no se ha mencionado en ningún lugar de la localidad o el lugar en donde se encontró ese vehículo. De lo que estamos viendo, entonces el vehículo fue encontrado en otro lado.
I believe that the witness testified to a blue vehicle crash near Carthage College.
Yo creo que el testigo había testificado que se encontró el vehículo cerca a Carthage College.
Ms. McNeil?
Señora McNeil.
So the question was, what did law enforcement do next?
Entonces la pregunta era, ¿qué es lo que la policía hizo después?
Well, the driver was identified as Jose Ramirez, and Deputy Johnson asked him if he was driving that vehicle, and he admitted that he was.
El policía Johnson le preguntó al señor Ramírez si es que él... I'm sorry, could you please repeat your answer?
Deputy Johnson asked Mr. Ramirez if he was driving the vehicle, and he admitted that he was.
El policía Johnson le preguntó al señor Ramírez si él estaba conduciendo el vehículo y él dijo que sí.
Based upon your review of the criminal complaint, did Deputy Johnson specifically ask the defendant whether he was involved in the crash on Sheridan Road by the Villa Rosa apartments?
Basado en su conversación con...
the criminal complaint is not evidence, it is an allegation. And
Voy a
so-
objecionar porque la acusación es un alegato, no es evidencia.
Therefore, my position is it's improper to rely on the criminal complaint alone. And if you review Deputy Johnson's report, that's different. But reviewing the criminal complaint, this is just some paralegal's interpretation of, and we don't even know who necessarily interpreted this. And therefore, it has no reliability.
La acusación fue escrita por un paralegal, o sea, una persona que escribió este informe, así que eso no es evidencia. Quizás se pueda leer y confiar en lo que escribió el policía Johnson, pero esta acusación no es ninguna evidencia.
Additionally, it's a document intentionally that is drafted for purposes of litigation, which again is the basic reason why the hearsay rule was instituted, was to prevent documents generated for purpose of litigation from being introduced into trial.
Este documento fue escrito y este tipo de documentos son escritos para propósitos de litigación judicial y de acuerdo a la ley eso se puso de que este tipo de cosas no pueden ser presentadas como evidencia en un juicio.
All right, well, you've preserved your right to object, but I do find at this juncture that the current status of law provides that hearsay testimony is reliable for purposes of determining whether probable cause exists.
Ok, bueno, usted ya puso su objeción, entonces yo declaro de que la ley indica de que el testimonio de rumor que se da en una acusación es confiable en términos de encontrar causa probable.
And is allowable pursuant to section 970.038 of the Wisconsin statutes.
Y esto es fundamentado en la ley 970.038 de las leyes de Wisconsin.
And further allowable pursuant to the case
Y además es permitido según el caso
State v. O'Brien,
del Estado versus O'Brien,
354 West 2nd, 753.
354 West 2, 753,
2014 case.
caso del 2014.
Also, I find that a review of the booking photo
También veo de que la revisión de la foto que se tomó en la cárcel
constitutes more of a review
constituye más que una revisión,
than just a review of the criminal complaint alone.
que solo una revisión de la acusación por sí sola.
As such, it was a heightened level of review.
Por lo tanto, hay una revisión más alta que se dio.
So for that reason, Mr. Ward, at this juncture, I'm going to deny your objection
Por esa razón, señor Ward, voy a denegar su objeción
and overrule.
y lo voy a denegar.
So to go back then, my question was, based upon your review of the criminal complaint, did Deputy Johnson specifically talk to the defendant about any involvement he might have had with the crash by the Villa Rosa apartments?
Entonces, en base a su revisión, entonces, de la acusación de lo que el policía Johnson ha dicho de que él había hablado con el acusado y le preguntó sobre su involucramiento en el choque que ocurrió cerca de los apartamentos Villa Rosa.
Yes, Mr. Ramirez admitted to being involved in that accident and stated he left the scene because he did not have a driver's license.
Sí, el señor Ramírez sí admitió que él estaba en ese accidente y que se fue porque no tenía licencia de conducir.
Did the defendant specifically say what had occurred to cause the accident?
El acusado dijo específicamente qué ocurrió, que ocasionó el accidente.
I believe he stated he was going to Villa Rosa and he stated he turned in front of that silver vehicle.
Yo creo que él dijo que él iba hacia los apartamentos Villa Rosa y cuando dobló o cuando volteó, entonces ahí estaba el otro vehículo.
And did he indicate that when he turned is when the accident occurred?
Y él le dijo que cuando él dio la vuelta ahí, es cuando ocurrió el accidente?
I'd have to refresh my memory to make sure that he actually said that, but I do vaguely recall that.
Vagamente recuerdo eso, tendría que refrescar mi memoria para ver si es que él en realidad dijo eso.
So would it refresh your memory to look at the criminal complaint?
¿Le refrescaría la memoria si usted ve la acusación?
Yes.
Sí.
So I would specifically like to direct Deputy Gott to look at page 5 of the criminal complaint and the paragraph in the middle directly below the prior convictions for the defendant.
Entonces, quiero que el policía Gott mire la página 5, el párrafo del medio, justo antes de donde dice los antecedentes del señor Ramírez.
All right, Deputy Gott, once you may refresh, and once you refresh your memory, please set aside that criminal complaint and then let us know that you're ready to answer the question.
Policía Gott, por favor, refresque la memoria con esa acusación. Una vez que lo haya hecho, entonces ponga de lado esa acusación.
Okay, I did review it and refresh my memory, and he did say that he turned in front of the silver vehicle and it caused the accident.
Sí, ya refresqué mi memoria, ya lo vi, y sí me acuerdo que él sí dijo de que él volteó y le pegó al vehículo azul enfrente del departamento.
And to be clear, you were saying he, so who were you referring to making that statement?
Y cuando usted dice que él hizo esto, ¿a quién se estaba refiriendo?
Mr. Ramirez.
Al señor Ramírez.
Did Deputy Johnson notice any signs of impairment from his interaction with the defendant that day?
Y el policía Johnson notó algún impedimento que él tenía durante esa, digamos, ese encuentro con el acusado ese día.
Yes, Deputy Johnson indicated that when they were on scene of the crash near Carthage College, the defendant had red, glassy eyes and was having trouble maintaining his balance and standing.
Sí, el policía Johnson dijo de que cuando estuvieron en la escena ahí en Carthage College, entonces el acusado tenía los ojos rojos y vidriosos y no podía mantener muy bien su balance.
Did Deputy Johnson conduct the standardized field sobriety tests on the defendant?
Y entonces el policía Johnson condujo los exámenes de sobriedad estándares que se dan ahí en la escena del accidente, ahí en la escena.
Yes.
Sí.
And based upon your review of the criminal complaint, how did the defendant perform on the horizontal gaze nystagmus test?
Y entonces, de acuerdo a su revisión del examen que se le dio a él, de la vista horizontal o del alineamiento, ¿cómo él hizo ese examen?
He showed several clues indicating a high level of intoxication.
Él mostró varias señas en relación a dar señales de embriagamiento.
And do you specifically recall which clues he showed?
¿Se acuerda específicamente qué señales fueron esas?
I believe Deputy Johnson observed a lack of smooth pursuit in both eyes.
Y yo creo que el policía Johnson vio una carencia de poder seguir con los ojos bien.
Onset of nystagmus prior to 45 degrees and nystagmus at maximum deviation.
Y también el poder controlar la vista con una desviación normal.
And so is that all 6 clues on that test?
Esas fueron las 6 señas que dio ese examen.
Yes.
Sí.
Did Deputy Johnson have the defendant perform the walk and turn field sobriety test?
Y el policía Johnson hizo que entonces el acusado haga el examen de caminar y voltear.
Yes.
Sí.
And how did the defendant perform on that test?
¿Y cómo le fue a él en ese examen de sobriedad?
he also showed several clues on that test.
Él también mostró algunas otras señas en ese examen.
Do you specifically remember the clues the defendant showed on that test?
¿Se acuerda específicamente qué señas él dio en ese examen?
I don't recall all of them, but I know that he used his arms for balance, stepped off the line, did an improper turn, took 10 steps. And there may be more. I would have to refresh my memory to make sure.
No me acuerdo muy bien, pero yo creo que él utilizó sus brazos para poder balancearse, tanto como no seguir la línea bien o no poder voltear bien, y también tomaba más pasos de los adecuados.
I am asking that Deputy Gott be allowed to refresh his recollection using the criminal complaint. In particular, I am referring to page 4 of the criminal complaint, the last full paragraph.
All right, thank
I'm
you.
gonna
May I do
object.
so? What are you objecting to, Mr. Ward?
¿Cuál es
It's
su
not a
objeción?
refreshing of his recollection, it's a rereading of the criminal complaint. If she wants to refer to the criminal complaint, have the court take judicial notice of it, but to call it refreshing recollection is a travesty.
No es para refrescarse la memoria, puesto de que lo que realmente está preguntando es simplemente para que revise la acusación, porque realmente esto es un desastre que ella pregunte eso de esa manera.
Well, I'm going to overrule the current status of the law allows such a refreshment. The court's understanding. Go ahead, Deputy Gott.
Voy a negarle entonces su objeción, puesto que la ley sí permite ese tipo de refrescarse la memoria. Adelante, policía acá.
Okay, I'm ready. He swayed from left to right, stepped off.
Deputy Gott, is your memory refreshed?
Yes, it is.
Then you
¿Ya
may
se
proceed.
refrescó la memoria? Sí, adelante.
And you took the complaint and moved it away from you?
Yes, it's to the side where I can't see it.
¿Y ya
All right,
tomó
you
la
may go.
acusación y lo puso de lado? Sí, ya lo hice.
You may answer
Adelante.
the question.
Responda la pregunta.
He swayed from left to right, stepped off the line, used his arms to balance, and did an improper turn.
Entonces, él se zigzagueaba de izquierda a derecha, no seguía la línea correctamente, utilizaba sus brazos para poder balancearse y no volteó de manera adecuada.
And based upon your training and experience, are those clues of intoxication on that test?
Y de acuerdo a su experiencia y entrenamiento, ¿esas son señales de embriagamiento en ese examen?
Yes, they are.
Sí.
Did Deputy Johnson have the defendant perform the one-leg stand field sobriety test?
Y el policía Johnson hizo que él haga el examen de sobriedad para que él se ponga de pie en un solo pie, en una sola pierna.
Yes.
Sí.
Did the defendant show any clues on that test?
Y el acusado sí mostró alguna seña en ese examen también.
During that test, he swayed and he also picked up one of his legs and then immediately put it back down and stated he could not do the test.
Durante ese examen, él entonces no se podía balancear de derecha a izquierda y también se tocó uno de sus pies para poder, digamos, balancearse, pero después lo dejó. Y dijo que no podía hacer el examen.
Did Deputy Johnson then ask the defendant whether he would take a preliminary breath test?
Y el policía Johnson le preguntó al acusado si es que él podía tomarse un examen del aliento preliminar.
Yes, he did ask and Mr. Ramirez refused.
Sí se lo preguntó, pero el señor Ramírez se rehusó.
What did Deputy Johnson do after having the defendant perform those tests?
¿Qué es lo que el policía Johnson hizo después de que él le hizo todos esos exámenes a él?
He asked him if he would consent to a test of his blood, a blood draw.
Entonces el policía Johnson le preguntó a él si es que él daba consentimiento para que se le sustraiga un poco de sangre.
And did Deputy Johnson arrest the defendant?
Y el policía Johnson arrestó al acusado.
Yes.
Sí.
And for what did Deputy Johnson arrest the defendant?
¿Y por qué razón lo arrestó al acusado?
For operating while intoxicated.
Por conducir bajo los efectos de un embriagante.
Now, Deputy Gott, based upon your review of the criminal complaint, does the defendant have prior convictions that count as priors for OWI?
Policía Gott, después de su revisión de la acusación, ¿el acusado tiene algún antecedente de haber conducido antes bajo los efectos de un embriagante?
Yes, he does. He has 2 priors.
Sí, él tiene 2 condenas anteriores.
And according to the criminal complaint, are both of those priors out of Kenosha County?
Y de acuerdo a la acusación, esos son 2 casos anteriores en el condado de Kenosha.
Yes.
Sí.
And do you recall the dates of those priors
¿Y
convictions?
se acuerda usted la fecha de esos 2 antecedentes?
I don't recall the exact dates. I believe one was in 2011 and the other one was either 2016 or 2018. I'm not positive.
No me acuerdo exactamente, pero yo creo que fue una de ellas en el 2011 y la otra fue en el 2016, 2018, no me acuerdo bien.
Would it refresh your recollection to review the criminal complaint to show you the dates of the prior conviction?
¿Le refrescaría la memoria si usted ve la acusación para que usted vea las fechas específicas de esos 2 antecedentes?
Yes.
Sí.
And I am specifically referring to page 5 of the criminal complaint, where it has that paragraph followed by conviction date.
Sí, estoy entonces dirigiéndole a la página 5 de la acusación, donde está el párrafo en la que igual menciona las fechas de las condenas.
All right, is your memory refreshed,
Yes.
Deputy?
Bien, ¿ya se refrescó su memoria?
Yes.
Sí.
So what were the dates of the defendant's prior OWI related convictions?
¿Y cuáles son las fechas de antecedentes de conducir en estado de ebriedad anteriores del acusado?
It'll be 6/10 of 2011 and 8/22 of 2018.
El 10 de junio del 2011 y el 22 de agosto del 2018.
I have no further questions.
No tengo más preguntas.
Thank you, Ms. McNeil.
Gracias, señor McNeil.
Mr. Ward, you may cross-examine the deputy.
Señor Ward, usted puede ya interrogar al policía.
Where in relation to Carthage College was Mr. Ramirez's vehicle found?
¿En dónde, en relación al Carthage College, se localizó el vehículo del señor Ramírez?
It was in the 2000 block of Alfred Park Drive.
Era en la cuadra 2000 de Alfred Park Drive.
And isn't it true that they found it after it had hit a light pole? Is that correct?
¿No es cierto de que lo localizaron después que se había chocado con un poste de luz, no?
Yes, correct.
Sí, correcto.
And the light pole actually fell down. Is that correct?
Y el poste de luz se derribó, ¿no?
I believe the light pole was damaged. I don't know for sure if it fell down.
No estoy seguro si se cayó completamente, pero sí tuvo daños que ocurrió con ese poste de luz.
Prior to Deputy Johnson performing field sobriety tests, did he do a concussion protocol?
Antes de hacer los exámenes de sobriedad, el policía Johnson, él hizo alguno de los protocolos de tener algún trauma en la cabeza.
Not that I'm aware of.
So, to your knowledge, he did not screen him for a concussion.
O sea que no lo revisaron por algún tipo de contusión que él haya tenido.
Correct.
Correcto.
Isn't that one of the things you're supposed to do in a field sobriety test is screen for innocent explanations for clues?
Pero no es algo que ustedes deberían hacer antes de hacer esta prueba a las personas de ver algunas señas inocentes antes de todo esto.
I don't know if Deputy Johnson would have the knowledge to do that.
No sé si el policía Johnson tendría el conocimiento de hacer estas cosas.
So you don't know that Deputy Johnson is qualified to do field sobriety tests, correct?
O sea, usted no sabe que si el policía Johnson está calificado para hacer exámenes de sobriedad, ¿no?
That's argumentative.
I'm going to sustain that objection.
Me opongo a esa pregunta, es argumentativo. Voy a sostener esa objeción.
do you have any knowledge as to whether Deputy Johnson is qualified to do a field sobriety test?
¿Usted tiene algún conocimiento para ver si el policía Johnson está calificado para hacer un examen de sobriedad?
I do not have knowledge of his training records, no.
No tengo ningún conocimiento de sus registros de entrenamiento, no.
It is fair to say that the field sobriety test, if not done properly, basically has no predictive results. Strike that. If the field sobriety test is not done accurately, is it not true that it is useless to predict whether someone's intoxicated?
No es cierto de que si un examen de sobriedad no se hace de manera exacta, realmente no tiene validez sobre los resultados que se obtiene con este examen de sobriedad.
I would not agree that it would be useless, no.
No estoy de acuerdo con la palabra que no tiene validez.
So it is your opinion that an improperly applied field sobriety test can give you predictions as whether someone's intoxicated?
O sea, lo que usted dice es que un examen de sobriedad hecho de manera inapropiada le puede dar resultados, digamos, correctos cuando se hace el examen de sobriedad.
That's not what I'm saying. There are numerous things that they're looking for, and yes, one error could cause issues.
No es lo que estoy diciendo. Lo que estoy diciendo es que hay diferentes maneras de hacerlo y un error puede ocasionar problemas.
With regard to the field sobriety test, the first one you talked about was the HGN test, correct?
Correct.
En relación al examen de sobriedad, usted mencionó de que el primer examen que se hizo es la prueba HTN, ¿no? Sí.
Wait, Mr. Ward, I'm gonna have a question here. Are you going to ask this deputy about what he does as far as field sobriety tests or what he knows about field sobriety tests? Or are you going to ask what this deputy can only testify to is what's written in the criminal complaint, what the other deputy did?
Abogado Ward, lo estoy preguntando si es que usted le está preguntando a este señor si es que él sabe lo que él debe hacer cuando se hace un examen de sobriedad o de lo que el informe dice de que el otro policía dijo que de cómo lo hizo.
Right now, I'm going to be asking about facts with regard to the field sobriety test to the best of the deputy's knowledge.
Ahora estoy preguntando simplemente sobre los hechos de un examen de sobriedad de acuerdo al conocimiento de este policía.
So you're asking then what this deputy knows about field sobriety tests, is that correct?
Entonces usted estaría preguntando sobre si este policía sabe qué es lo que es un examen de sobriedad.
I mean, that's where at this point, my next question isn't there. I would like to ask my next question and the court will see where I'm going.
Bueno, si me permiten hacer la próxima pregunta, quizás el tribunal va a saber hacia dónde voy con esto.
What the court would like is you to answer the court's question.
Okay.
Lo que el tribunal quiere es que usted responda la pregunta.
I intend to ask about, the next question is going to be about the weather conditions, Your Honor.
La próxima pregunta va a ser sobre las condiciones del clima, su señoría.
Then I will be asking him about based on his knowledge, what the impact of those conditions would be.
Y después le voy a preguntar, basado en su conocimiento, cuáles fueron el impacto de todo esto.
So here's the key. It again seems like you're going, first off, you're engaging in what appears to be discovery.
Okay, eso es lo que tengo que decir. Usted ahora está hablando sobre la revelación de datos.
And
I'm
next
going to
year,
reliability, Commissioner.
I'm still speaking, Mr. Ward, excuse me.
Estoy hablando, disculpe.
And then you're going into whether or not the tests that were at this point administered by Deputy Johnson have issue or cause, which I believe that's a better question for trial and Deputy Johnson.
Entonces, la próxima cosa que usted está preguntando es sobre los exámenes, entonces, que hizo el policía Johnson para ver si hay algún problema o alguna causa en eso. Yo creo que esas son cosas para un juicio.
Ms. McNeil, anything you'd like to add?
Señora McNeil, ¿algo que quiera añadir?
No, I have nothing further.
All
No
right.
tengo más que añadir.
Your Honor, I have a right to go after the reliability, especially when we're dealing with intoxication. And it appears that the state is, at this point in time, trying to imply intoxication based upon the performance of a field sobriety test only. Well, I would
Entonces-
normally agree if we had a blood result or we had a breath result, that my questions may be more properly for trial. Where we are now making an expert opinion, we have the right to show that the expert opinion is unreliable.
Tenemos el derecho a refutar la opinión de un experto. Estoy hablando ahora sobre la confiabilidad de todo esto, porque la fiscalía está diciendo de que sobre el embriagamiento está, digamos, asumiendo que los exámenes son hechos de esa manera, cuando en realidad si hubiese tenido un examen de sangre o de aliento, podría ser otra cosa. Entonces, algo que trataríamos nosotros en el juicio.
May I assume you're speaking about the expert opinion of Deputy Johnson, who administered the tests?
¿Puedo subir entonces que usted está hablando sobre lo que el policía Johnson hizo al hacer el examen? Correcto.
Well, Deputy Johnson isn't testifying, it's Deputy Gott. If you're going to go on simple what this deputy knows in terms of how to administer these tests, I believe at this point that goes beyond the plausibility of a story. It goes to credibility in terms of Mr. or Deputy Johnson.
Bueno, yo creo que si usted está preguntando sobre cómo se debe hacer el examen, yo creo que esto, usted ahora está hablando no está hablando con el policía Johnson. Yo creo que tiene mucho que ver con la credibilidad y eso tendría que hacerlo, esas preguntas estarían dirigidas al policía Johnson.
But I'll tell you what, Mr. Ward, I'll let you ask a few questions, but let's not stay with this line of questioning for a great length, okay?
Le voy a permitir hacer algunas preguntas, pero por favor no se mantenga en esta línea de cuestionamientos.
Deputy, what was the weather conditions like that day?
Señor policía, ¿cuáles eran las condiciones de clima en ese día?
It was raining that day.
Estaba lloviendo.
And what is the impact of raining on, if it's raining into a suspect's eyes, how does that impact his response to the HGN test?
¿Y cuál es el impacto de la lluvia en el ojo de una persona? ¿Cómo impacta eso en un examen HTN?
Okay, and again, that assumes a fact that hasn't been testified, that rain was coming into the client or your client's eyes. And again, you're asking this detective, or excuse me, this deputy to testify as to a fact, not an evidence.
Usted está haciendo esta pregunta sobre algo que no ha sido testificado todavía, de que se le haya caído lluvia a los ojos de una persona, pero usted le está preguntando a esta persona otra vez, a este policía.
Now, this deputy testified as to having, obviously through training and experience, knowledge, working knowledge and application of the field sobriety tests.
Este policía ha hablado que tiene conocimiento de cómo hacer un examen de sobriedad.
However, I'm going to allow the question. Again, what this deputy can or cannot testify to will be up to the deputy.
Voy a hacer que usted continúe las preguntas, pero de lo que pueda testificar o no, entonces voy a dejarlo al policía al que usted le está preguntando.
I believe in this circumstance, Mr. Ramirez was actually taken to the Sallyport in the jail for these tests because of the rain.
Yo creo que el señor, en estas circunstancias, al señor Ramírez se le llevó en la cárcel, digamos, al Sallyport.
Okay, so your testimony is that, to your knowledge, all the testing occurred in the Sallyport in the jail?
Y entonces usted está diciendo que todo esto, ocurrió, estas observaciones ocurrieron en el Sallyport de la cárcel.
I believe so.
Creo que sí.
Now, let's go to the next area. Deputy, isn't it true that my client speaks primarily Spanish?
Ok, vamos a otra línea de cuestionamientos. Señor policía, ¿usted sabe de que mi cliente habla primordialmente español?
That was his claim, yes.
Eso es lo que él decía, sí.
Does Officer Johnson speak Spanish?
¿El policía Johnson habla español?
I don't believe so, but I don't know.
No creo, pero no lo sé.
Again, this gentleman was questioned in English, is that correct?
Este caballero fue interrogado en inglés, ¿no es cierto?
I do have knowledge that there was a correctional officer working that spoke Spanish that was in the Sallyport with Deputy Johnson.
Tengo conocimiento que había un empleado ahí de la correccional que hablaba español que estaba ahí en el Sallyport con el policía Johnson.
But Mr. Ramirez was questioned at the scene, isn't that correct?
Pero el señor Ramírez fue interrogado en la escena, ¿no es cierto?
I believe there was some questioning in both locations.
Creo que hubo interrogaciones en ambas localidades.
Do you know whether Mr. Ramirez was asked about what happened with the accident in English or Spanish?
¿Usted sabe si es que le preguntaron al señor Ramírez sobre qué ocurrió? ¿Se lo preguntaron en inglés o en español?
I'm not sure.
No estoy seguro.
Was there damage also to the front of Mr. Ramirez's vehicle?
¿También sufrió daños la parte del frente del vehículo del señor Ramírez?
I don't know. I did not see his vehicle.
No lo sé, no vi su vehículo.
With regard to Mr. Dotson, did he say where he was coming from?
En relación al señor Dotson, ¿le dijo a él desde dónde venía él?
Mr. Dotson said he was going to Kenosha from Racine.
El señor Dotson dijo que iba hacia Kenosha desde Racine.
Did he say where he was coming from in Racine?
I'm objecting. That's
¿Le
not
dijo de dónde venía él en Racine? Estoy objecionando la pregunta.
Sustain, that's discovery.
Muy bien, entonces yo sostengo la objeción, puesto de que eso es una revelación de datos.
No further questions.
No tengo más preguntas.
All right, thank you. Any redirect, Ms. McNeil?
Gracias. ¿Hay alguna otra pregunta, señor McNeil, que usted tenga?
I have no redirect.
No tengo ninguna.
Deputy, thank you. Your testimony is concluded.
Señor policía, gracias. Su testimonio ha concluido.
Ms. McNeil?
Señora McNeil.
The state has no further witnesses, and as the defense has indicated they do not have witnesses, I move for bind over.
La fiscalía no tiene ningún testigo, tanto como la defensa también dijo que no había ningún testigo. Yo entonces pido que este caso sea procesado de aquí en adelante.
Mr. Ward.
At this point, I would object to bind over on a felony. I think this is properly, would be bound over for a hit and run injury, which would be a misdemeanor, but I don't believe there is sufficient evidence from where a court could find probable cause on the causing the injury by intoxicated driving. At this point, the court is asked to speculate about whether or not my client was intoxicated. We don't have a blood alcohol level. We don't have a reliable, in my view, a reliable set of field sobriety tests where the court can make an independent determination that the field sobriety tests were done properly and therefore can give a good predictive probable cause belief that my client was intoxicated.
Su señoría, nosotros objecionamos a que esto sea procesado de aquí en adelante como un delito mayor de chocar, irse a la fuga y después de ocasionar lesiones. No creo que haya suficiente evidencia para dar un cargo de conducir bajo los efectos de un embriagante o de que se tenga algún tipo de nivel de alcohol en la sangre, porque también los exámenes que se han hecho no puede que no sean confiables, y lo que se necesita es que un tribunal dé una determinación para ver si esto es aceptado o no de acuerdo a los niveles de predictibilidad que tendría en este caso.
All right, thank you, Mr. Ward.
Gracias, señor Ward.
I do find, once again, as I indicated earlier, that hearsay testimony is reliable for purpose of determining whether probable cause exists.
Sí, declaro de que el testimonio de rumor es confiable para términos de poder aceptar una causa probable en este caso.
and is allowable pursuant to section 970.038
y es permisible de acuerdo a la ley 971.038
of the Wisconsin statutes,
de las leyes de Wisconsin.
and further pursuant to the case
Y además con el caso de
State v. O'Brien,
Estado versus O'Brien,
354, Wis. 2nd, 753, 2014 case.
es el caso 354 WIS 2 de 753, un caso del 2014.
And further, all reasonable conflicting inferences are resolved in favor of the state at this juncture.
Y todas las inferencias conflictivas se han resuelto a favor de la fiscalía en este tramo.
And as I further indicated, a heightened level of review is involved with the review of a booking photo.
Y también, como había dicho, la revisión alta o de nivel alto que se dio fue dado con una foto que se tomó en la cárcel.
And that constitutes more of a review than just a review of the criminal complaint alone.
Y eso constituye más que una revisión aparte de solo la acusación.
Therefore, based upon the testimony presented today,
Por lo tanto, después de escuchar el testimonio de hoy,
I do find that the state has demonstrated probable cause that a felony was committed,
sí declaro de que la fiscalía ha demostrado que probablemente se cometió un delito mayor
relating to the counts in the complaint, and
en relación a los cargos de la acusación y
probable cause exists that this defendant committed that felony,
que existe causa probable de que este acusado probablemente cometió este delito mayor.
therefore this defendant and this case are bound over
Por lo tanto, este caso y este acusado van a ser procesados
before the Kenosha County Circuit Court,
ante el Tribunal del Condado de Kenosha,
before the Honorable Bruce E. Schrader,
ante el honorable juez Bruce E. Schrader,
presiding.
quien preside su sala.
I also have an information which has been filed,
También tengo aquí una información de datos que se puso,
so we may move to arraignment.
entonces vamos a proceder a la lectura de cargos.
Mr. Ward, did you receive a copy of the information?
Señor Ward, ¿usted recibió una copia de la información?
I did not.
No.
Ms. McNeil, have you?
I sent it approximately 5 minutes ago.
La secretaria dice, yo lo envié hace como
I
5
just
minutos.
checked my email, so I don't.
Acabo de revisar mi correo.
Possible- Did she send it to my main office email?
¿Lo envió al email principal de la oficina?
Yes, it went to the law office email.
Sí,
That's
fue
not
a
my
la...
If the poll, excuse me, I'll go see if I can get it.
Sure, go ahead, Mr.
Ok,
Ward.
un momento, por favor. Quisiera ver si es que me pueden permitir obtenerlo. Sí, no, está bien.
Okay.
And just while we're waiting, Alberto, it looks like I might need you for one more case quick after this, so don't disconnect.
Sure.
Okay, Commissioner, I did receive the information. I'll acknowledge receipt of the information. I'll waive its reading. I'm continuing my objection to the bind over determination, reserving and preserving our right to file de novo review pursuant to local rules within 15 days.
All right, thank you.
Su señoría, reconozco
Oh,
haber
sorry.
recibido la acusación, entonces nosotros estamos todavía en objeción a que esto proceda a un proceso, a ser procesado, y también tenemos en cuenta de que nosotros tenemos el derecho de que esto se vuelva a revisar otra vez en una audiencia de nuevo.
All right, well, then the court will enter not guilty pleas to each of the counts contained in the criminal information.
El tribunal entonces va a poner una declaración temporal de no culpable de acuerdo a los casos aquí puestos en la acusación.
As well as I'm entering not guilty pleas in the 3 TR files.
También estoy poniendo una declaración de no culpable en los 3 casos de tránsito.
That's 20 TR 3056,
20 TR 3056,
TR 3057,
3057,
TR 3058.
TR 3058.
And we'll have the matter calendared before Judge Schrader for further proceedings.
Vamos a procesar esto y vamos a poner en el calendario del juez Bruce E. Schrader para su proceso futuro.
Pre-trial conference with Judge Schrader, August the 13th at 10 o'clock.
That would be fine.
Con el juez Schrader, entonces la audiencia será el 13 de agosto a las 10 de la mañana.
To go with that, jury selection is August 31st at 9 o'clock.
La selección del jurado entonces sería puesta para el 31 de agosto a las 9 de la mañana.
All right, thank you, everyone. That'll conclude the hearing.
Muy bien, gracias. Esto concluye la audiencia.
You can have a seat over there. We'll get you a copy of the criminal.
I believe I'm going to bring a defendant into the courtroom who does not have counsel and will need some interpretation services. Mr. Aguilar, if you may.
Yes, Your Honor.
All right, thank you, sir.
I just need the case information.
It's going to be State of Wisconsin versus Antonio Sanchez Flores.
Do you have a case number?
Yes, 20 CF 653.
Okay.
All righty. All right, great, thanks. All right, I will now call the matter of the State of Wisconsin versus Antonio Sanchez Flores, 20 CF 653.
Muy bien, ahora voy a llamar al caso del estado de Wisconsin versus Antonio Sánchez Flores, caso 20CF653.
The state appears, oh, sorry. The state appears by Carly McNeil.
La fiscalía comparece con la abogada Carly McNeil.
Sure, are you Antonio Sanchez Flores?
Señor, ¿es usted Antonio Sánchez Flores?
Sí, correcto.
Yes, correct.
All right, and your first name is spelled O-T-O-N-I-E-L, is that correct, sir?
Que su nombre es deletreado O-T-O-N-I-E-L, señor Otoniel?
Correcto.
Correct.
Thank you, sir. Now,
Gracias.
Mr. Sanchez Flores, you're appearing here today without an attorney.
Señor Sánchez Flores, usted comparece hoy sin abogado.
Cuando estuve en la cárcel, tuve un public defender y dijo que él me iba a ayudar.
When I was in jail, I had a public defender and he said he was going to help me out.
Okay. I believe it's important for you that you have an attorney representing you in this case.
Yo creo que es importante que usted tenga un abogado que lo defienda a usted en este caso.
You have a right to represent yourself if you wish to do so, but I do not recommend that you do that.
Usted tiene el derecho de defenderse a sí mismo sin abogado, pero no recomiendo que lo haga.
And I don't know if you're eligible to have an attorney appointed to represent you through the public defender's office or not.
No sé si usted es elegible para que un abogado del defensor público lo pueda ayudar a usted o no.
But I do believe it's important that you have an attorney representing you in this case.
Pero yo creo que es importante que usted tenga un abogado que lo represente en este caso.
Me parece bien lo que me está diciendo el juez, pero la verdad no tengo cómo pagar un abogado.
I think it is good what the judge is telling me, but honestly, I don't have money to pay for an attorney.
I propose then, we're giving you a document here. It's in English, but I want to give you the phone number for the state public defender. So you can call the state public defender to see if you're eligible, okay?
Estoy dando un documento ahí sobre información sobre el defensor público. Le voy a dar el número telefónico para que usted se comunique con ellos, ¿ok?
So do you want to, I'll give you the number and I believe it's on that paper that we've given you, but I want to verify that.
Le voy a dar el número, pero yo creo que está ahí puesto ahí en ese papel que le acaban de dar, pero vamos a verificarlo.
So again, for you, that the public defender's telephone number is, area code is 262-653-6404.
El teléfono es área 262, teléfono 653-6404.
Is that number on that paper we've given you?
¿Ese número está escrito ahí en el papel que le acaban de dar?
Sí, ya lo tengo, me lo dio el oficial.
Yes, I have it. The officer gave it to me.
All right. What I propose to do today is to have your preliminary hearing rescheduled so you're not required to represent yourself today.
Lo que entonces voy a recomendar es que su audiencia preliminar sea fijada para otra fecha para que usted comparezca con un abogado y no se represente a sí mismo.
I'd like to give you time so that you can call the public defender and to have it determined if you're eligible to have an attorney represent you through that agency.
Le voy a dar un poco de tiempo para que usted llame a la oficina del defensor público para ver si es que ellos pueden darle un abogado que lo represente de esa agencia.
Would that be okay, sir?
¿Estaría bien eso, señor?
Me parece perfecto. Solo quería pedirle al judge si la corte pudiera ser un lunes.
I think it's perfect. I would just request the judge to see if that next hearing would be on a Monday.
Okay, we can check, because what we do, sir, is we'll set it down for what's called an attorney status hearing.
Vamos a revisar eso, señor, pero la audiencia próxima sería una audiencia de estatus o de estado para ver si un abogado ha sido asignado o no.
To make sure that you have an attorney.
Simplemente para asegurarnos que usted tenga abogado.
So we can put it on a Monday, but it's going to be a few weeks out if that's okay with you.
Podemos ponerlo en un lunes, pero van a ser en varias semanas. No sé si eso está bien con usted.
Siempre cuando es el lunes se lo agradecería mucho al judge.
As long as it's on Monday, I would be really grateful with the judge.
All right, we'll do that.
Muy bien, lo haremos.
Court will find that this defendant, Mr. Sanchez Flores,
el tribunal declara que el señor Sánchez Flores, el acusado,
knowingly and intelligently waived time limits,
de manera libre e inteligente está renunciando a los tiempos límites que tiene su caso,
to have his preliminary hearing calendared out beyond the 20-day statutory limit,
para poder fijar la fecha de la próxima audiencia más allá de los 20 días requeridos que la ley permite.
So the court will toll time.
El tribunal entonces va a sobrepasar ese tiempo límite.
For good cause to have Mr. Sanchez Flores determined if he is eligible to be represented by an attorney from the public defender's office.
Vamos a declarar que hay buena causa para hacer esta pospuesta esta prolongación de su audiencia para que el señor pueda obtener un abogado de la oficina del defensor público.
So we're going to give you a new court date. You come back here, we'll make it on a Monday at 1 o'clock.
Le vamos a dar una audiencia futura, entonces si usted pueda regresar, va a ser un lunes a la 1 de la tarde.
And we'll give you that date in just a second here.
En un momento le vamos a dar la fecha.
And remember, all bond conditions that were previously imposed remain in full force and effect, sir.
Y recuerde, señor, que las condiciones de fianza que nosotros le dimos continúan estando en vigor y en efecto hasta ese entonces, señor.
You understand?
¿Entendió?
Sí, no sé si es el momento para preguntarle al juez.
Yes, I don't know if it's a good time right now to ask the judge something.
Well, if you, here's the key. If you want to ask me a question, you can, but make sure you're not asking me or talking about your case or what happened, because you're presumed innocent right now.
Ok, tenga en cuenta de que usted puede hacerme alguna pregunta, con tal que no sea sobre el caso, porque ahora se asume de que usted es inocente.
Ok, sí lo entiendo.
Ok, yes, I understand.
Lo que pasa es que me dieron que no puedo llegar a mi casa, pero no tengo dinero para un hotel. He estado pagando 4 días de hotel y no sé cuándo puedo regresar a mi casa ni a sacar mis propiedades.
The thing is that they gave me, they told me that I cannot go back home. And I've been at a hotel for 4 days now, and I'm not able to take out my property, my belongings from that place.
Is there a condition of bond? Let me look it up, okay, real quick here.
Déjeme revisarlo un momento.
Yeah, gonna be a waiver.
Okay, sir, I looked at your bond
Señor, he visto su fianza
and you were allowed to send a third party, not yourself, but a third party to the residence of Ms. Hernandez within 24 hours of your signing the bond in this case.
En la fianza dice que a usted se le permitió mandar a un tercero a la casa de la señora Hernández dentro de 24 horas que usted haya firmado la fianza.
So did you send someone, not yourself, but did you send someone to retrieve the property and belongings, medications?
Usted mandó a una tercera persona, no usted, pero una tercera persona para que vaya por sus cosas, medicamentos o lo que sea suyo.
No, no lo hice. Llamé el número que me dieron, pero nadie me contestó.
No, I didn't do that. I called the number that I was given, but nobody answered.
Well, I'm not going to allow you to do it, sir. So the problem you have is I'm not allowing you to do it. And if there's no third party, then it's going to have to remain at that location for now.
No le voy a permitir, señor, por causa del caso, no le voy a permitir que usted vaya allá. Tiene que ser una persona, un tercero que pueda ir a obtener sus cosas.
But you can talk about it next time you're in court with me, if it's before me, or talk to your lawyer if you have a lawyer appointed to represent you about that as well.
Pero si usted quiere en la próxima audiencia podemos hablar de esto otra vez, o si usted ya tiene abogado para la próxima audiencia podemos retomar el tema.
Ok, mi problema es, yo entiendo de las cosas. Mi problema es que si puedo regresar a mi casa, no tengo dónde vivir.
Okay, I understand what you're saying, but I'm wondering, because my problem is I don't have a place to live, and I'm wondering if I can go back home.
Not now, sir.
Ahora no, señor.
Ok, entonces voy a regresar a Chicago con mi hermano, pero voy a perder mi trabajo. No puedo
Okay.
manejar tampoco.
That means that I'm going to go back to with my brother in Chicago, and I'm going to lose my job, and of course I can't drive.
All I can tell you, sir, is because of the allegations in this case, I'm not allowing you to go back home and have contact with the reported victim at this point.
Todo lo que le estoy diciendo, señor, es que usted no puede regresar a esa casa, no puede tener contacto con la víctima.
Next hearing is August the 3rd, and that'll be at 1 o'clock. Thank you.
La próxima audiencia va a ser el 3 de agosto a la 1 de la tarde. Gracias.
If you take him out there, I'll print a notice of hearing for.
¿Ya se acabó?
Is there anything else, Chanel?
No, Mr. Aguilar, thank you so much.
Thank you,
Appreciate your
Honor.
help. Thank you,
Thank you.
sir. All
Did
right.
not wipe down that seat?
All righty. I will call the matter of State of Wisconsin versus Matthew S. Bostrom, 20 CF 646. Appearances, please.
The state appears by Carly McNeil.
Matthew Bostrom appears in person and by video conference by Attorney Hillary Edwards.
All right, thank you, Ms. Edwards. This matter has been calendared for preliminary hearing. Is this to be a waiver? And if so, had you filed something? I'll check or not.
It is a waiver. I did file a while ago, but it appears not to have made it through. I filed waiver paperwork and a substitution request.
Okay, that's fine. I understand regards to waiver. All right, well then, has there been an offer? If so, Ms. McNeil, would you place the offer on the record, please?
Yes, the offer is not open. The offer is plead to count 1, dismiss the repeater, and count 2. The state to make no specific recommendation. The offer is subject to further negotiations. It is conditioned on the defendant complying with the terms of his bond, and it expires at the first judicial pretrial.
All right, thank you. Ms. Edwards, is that a correct recitation of the offer?
It sounded weird, but it's plead to count 1 without the repeater. Count 2 would be dismissed as well.
That's what I meant.
Okay, it didn't quite sound that way, but yes, then that's correct.
All right, and did you have enough time to discuss that offer with Mr. Bostrom?
Yes.
Did you also have enough time to discuss with Mr. Bostrom the waiver of the preliminary hearing today and the impact it'll have on his case?
Yes.
Thank you. Mr. Bostrom, you're in the courtroom with me, so I'll just address you directly. I have some questions for you, sir. To begin with, are you able to hear me okay?
Yes.
All right. Are you thinking clearly today?
Yes,
And did you hear the plea offer that was just placed on the record, sir?
I did.
Is that the same plea offer that you understand you received?
That is, yes.
And did you have enough time to discuss with your attorney, Ms. Edwards, that plea offer and its potential impact on you?
Yes,
Did you also have enough time to discuss with Ms. Edwards the waiver of the preliminary hearing and its impact on your case?
yes,
All right, and in regards to both the plea offer and the waiver of the preliminary hearing and impact, did Ms. Edwards answer any and all questions you might have had?
yes,
Just a few more questions then, sir. Do you understand that you did have a right to have the preliminary hearing held if you'd wanted it to be held?
yes,
You also have the right to waive the preliminary hearing, which is what I understand you wish to do today. Is that correct?
that is correct.
All right. Now you understand that a preliminary hearing is not a trial. It's one step in your case proceedings.
Yes,
And that, however, when you do waive your right to the preliminary hearing, sir, that's a permanent waiver. And that means that once the hearing's been waived, you may not come back before this court or any other court seeking to have another preliminary hearing. Do you understand that?
I do.
But even though you're waiving your right to the preliminary hearing today, sir, understand that you still have a right to have a trial in your case if you wish to have a trial. Do you understand that?
I do.
Also today, when you do waive your right to the preliminary hearing, that's a permanent waiver, as I said. But also what it means is this court is going to bind your case over for further proceedings before the Circuit Court of Kenosha County after the court is going to find that probable cause exists that a felony was committed and further probable cause exists to believe that you committed that felony. You understand?
Yep.
Okay. Also, well, let me ask you this, sir. Do you understand everything I've just explained to you, questioned you about, or discussed with you?
Yes.
Okay. Do you have any questions for me at this point?
No.
All right. If you have a question, make sure you ask it. Don't feel like you can't. Okay.
Okay.
Now, in regards to the plea offer, besides the plea offer, has there been any other offer given to you that I'm not aware of?
No.
All right. Did anyone threaten, force, or coerce you, Mr. Bostrom, to
No.
get you to waive the preliminary hearing?
No.
All right. Are you asking me then, sir, to accept your waiver of the preliminary hearing today?
I am.
All right. Thank you, Mr. Bostrom. All right. Ms. Edwards, any reason why the court should not accept the waiver?
No.
Thank you. Ms. McNeil?
No reason.
No. Okay. Thank you. Court then finds that Mr. Bostrom, the defendant, has freely, voluntarily, knowingly, and with the advice of competent counsel, waived the defendant's right to the preliminary hearing. Waiver is accepted, and the court does in this case find that probable cause exists that a felony was committed, and further probable cause exists to believe that this defendant committed that felony. Therefore, the matter is bound over before the Kenosha County Circuit Court for further proceedings. Now, Ms. Edwards has indicated that she filed a request for substitution of judge. I'll find that the request was timely made in its proper form, and as such, the matter originally had been counted before the Honorable Bruce E. Schrader. However, with the substitution, this matter shall now be counted before the Honorable Jason A. Russell for further proceedings, including arraignment, as Judge Russell will conduct his own arraignment. Nonetheless, I do have an information which has been filed, and I ask Ms. Edwards, do you acknowledge receipt of the information at this point?
I do, and I waive its reading.
Thank you very much. All right, the matter will now be counted, as I said before, for arraignment before Judge Russell. And Mr. Bostrom, just so you're aware, sir, any and all previously imposed bond conditions at this point remain in full force and effect, okay?
I'm sorry?
All the bond conditions that were previously imposed, they remain in full force and effect, all right?
Okay, and then those bond conditions don't apply until I actually get released on bond?
Okay, there was some, can you say that again? I had some.
The bond conditions don't apply until I'm actually out on bond?
Well, here's the key. All the bond conditions right now that were imposed regarding your release will be in full force and effect at that point. For more legal advice or concerns, I'd have to refer you to Ms. Edwards because I can't give you legal advice. All I can tell you is that all of those bond conditions that were previously imposed at this point remain in full force. If they apply after release, then of course, yes, that would answer your question, okay?
Sorry, arraignment with Judge Russell, August 21st at 8:30.
Thank you.
Thank you.
Thank you.
Mr. Cafferty.
I think I've signed them about 4 times. I did sign them, yeah. Okay, sure.
No, thank you.
If you start to.
Okay, there he is.
Morning.
Good morning. All righty, I will call the matter, the state of Wisconsin versus Victor A. Suarez Bucio, 20 CF 597. Appearances, please.
State appears by Carly McNeil.
Mr. Suarez Bucio and Attorney Patrick Cafferty appear by Zoom.
All right, thank you. This matter has been counted for preliminary hearing. Mr. Cafferty?
Your Honor, we are prepared to waive the preliminary hearing. I did submit a waiver form along with the offer form.
Let's see if it made it to filing.
Yes, sir. We had electronically filed that this morning.
Oh, good. And it made it. All right. The preliminary hearing waiver offer. Ms. McNeil, would you place the offer on the record, though, please?
The offer is plead to count 1, dismiss count 2. The state would make no specific recommendation at sentencing. The offer is open to further negotiations. It is conditioned on the defendant complying with the terms of his bond. It expires at the first judicial pretrial, and the state is in victim legislation compliance.
All correct.
All right, thank you, Mr. Cafferty. The preliminary hearing waiver form made it. The waiver of right to preliminary hearing, if you did file that document, it hasn't been uploaded yet, but I can address that in any event. Mr. Cafferty, did you have enough time, at least at this point, to discuss with Mr. Suarez Bucio the if you will, the plea offer and its potential impact upon him?
Yes.
You also have enough time to discuss with your client the waiver of the preliminary hearing and its impact on his case?
Yes.
All right, thank you. Mr. Suarez Bucio, I have some questions for you this morning. First off, are you able to hear me okay?
Yes, sir.
All right, just a point where you can't or it becomes garbled, please let me know.
Okay.
Okay, and next, are you thinking clearly today?
Yes, sir.
All right. Did you hear the plea offer that was just placed on the record?
Yes, sir.
Is that the same offer that you understood you received, sir?
Yes, sir.
And did you have enough time to discuss with your attorney, Mr. Cafferty, that plea offer and its potential impact upon you?
Yes, sir.
And did you also have enough time, sir, to discuss with Mr. Cafferty the waiver of the preliminary hearing and its impact on your case?
Yes, sir.
And again, regarding both the offer and the waiver of the preliminary hearing and its impact, did Mr. Cafferty answer any questions that you might have had?
Yes.
Okay. Do you remember also completing a document that was called the waiver of right to preliminary hearing?
Yes, sir.
And there were boxes on the document to be checked, answering questions on that document. Were the answers all true and accurate, sir, that you provided?
Yes, sir.
And did you have enough time to review the document and have any questions answered about the document by Mr. Cafferty?
Yes, sir.
Okay, any questions for me about the document?
No, sir.
All right. Just a few more questions then, sir. You understand that you did have a right to have the preliminary hearing held today if you'd wanted it to be held?
Yes, sir.
You also have the right to waive the preliminary hearing, which is what I understand you wish to do today. Is that correct?
Yes, correct.
All right. Now you understand that a preliminary hearing is not a trial. It's one step in your case proceedings.
Yes. Yes, sir.
But when you do waive your right to the preliminary hearing, sir, that's a permanent waiver, meaning that once the hearing's been waived, you may not come back before this court or any other court seeking to have another preliminary hearing. Do you understand that?
Yes, sir.
All right. And also, even though you're waiving your right to the preliminary hearing today, you understand that you still have a right to have a trial in your case if you wish to have a trial. Do you understand that?
Yes.
All right. And that also today, when you waive your right to the preliminary hearing, this court is going to make a finding that probable cause exists that a felony was committed and further probable cause exists to believe that you committed that felony. And this court will then bind your case over for further case proceedings. Do you understand that?
Yes, sir.
All right. Now, just a few more questions. Well, let me ask you, do you understand everything so far? I've questioned you about, discussed with you and explained to you?
That was everything. You got it.
Everything? Okay. Do you have any questions for me at this point?
No, sir.
All right. If you have one, make sure you ask it. Don't feel like you can't ask me a question. Okay.
Thank you.
Okay. You're welcome. Okay. Now, other than the plea offer that was given to you and placed on the record here, is there any other offer you were given that I'm not aware of?
Nope.
Okay. Did anyone threaten, force, or coerce you to get you to waive your right to the preliminary hearing?
No, sir.
All right. Then let me ask you this, Mr. Suarez Bucio. Are you asking this court then to accept your waiver of the preliminary hearing today?
Yes, sir.
All right. Thank you very much, sir. Mr. Cafferty, any reason why the court should not accept the waiver?
No, Your Honor.
Thank you. Ms. McNeil?
No reason.
Thank you. Court then finds that this defendant, Mr. Suarez Bucio, has freely, voluntarily, knowingly, and with the advice of competent counsel, waived the defendant's right to the preliminary hearing. The waiver is accepted, The court does find in this case that probable cause exists that a felony was committed, and further probable cause exists to believe that this defendant committed that felony. Therefore, this matter is bound over before the Kenosha County Circuit Court for further proceedings. Now, there's been no substitution request. Is that correct, Mr. Cafferty, or has there been?
There has not been.
All right, thank you. Then this matter is bound over before the Honorable Bruce E. Schrader for further proceedings. I also have an information that has been filed, Mr. Cafferty, so we may move to arraignment. Did you receive a copy of the information?
Yes, I'll waive reading and enter pleas of not guilty.
Thank you. Not guilty pleas are noted and entered for the record with respect to the 2 counts contained in the information. The matter, as I said before, will now be counted before Judge Schrader for further proceedings. Mr. Suarez Bucio, just so you're aware, sir, any and all previously imposed bond conditions at this point in your case remain in full force and effect, okay?
Okay.
Thank you, sir.
Thank you, sir.
Pre-trial conference with Judge Schrader, July the 30th at 9:40.
That's fine, thank you.
Okay, to go with that, jury selection is August 17th at 9 o'clock.
That's fine, thank you.
Thank you.
Thank
Have
you
a good
both.
afternoon.
Have a good
take care.
afternoon.
Bye-bye.
Okay, so.
Good morning, Mr. Celebrate.
Good morning, Janelle.
Patient.
No problem.
And Officer Dietrich, thank you.
All righty. Good morning, everyone. I will call the following cases. These are the State of Wisconsin versus Vandell M. Anderson. I have 3 felony files here. I have 19 CF 1449, 20 CF 139, and 20 CF 174, as well as the following TR files: 20 TR 842, 20 TR 843, 20 TR 844. Appearances, please.
The state appears by Carly McNeil.
Mr. Anderson appears remotely from the Kenosha County Detention Center in custody, and by counsel David Celebrate also appearing remotely.
All right, thank you. Mr. Anderson?
Yes, Your Honor. I would like to order a stay from any preliminary hearing of bond over decisions pending appealing your decision to deny my motion to dismiss, Your Honor.
All right, thank you, Mr. Anderson. Mr. Celebrate, you wish to be heard on that issue?
No, Your Honor, I believe it was addressed at the hearing earlier this week.
Right, yeah, we are going to hold these, they're either going to be waivers or we'll hold the hearings. You've preserved your right to appeal or seek a de novo regarding my bind over, sir. But these matters are now counted for preliminary hearing. And so I'm either going to hold the hearings today or there are going to be waivers of the hearings. Either way, whether they're held or whether they're waived, we're going to move forward. And whether there's a bind over even, we're going to move forward in each of these cases. But you, again, you've preserved your right, Mr. Anderson, to in effect appeal or seek a de novo of my decision, so you're aware of that.
Your Honor, I just wanted to request that the record reflect that no party is immune for civil liability pursuant 42 U.S.C. section 1983-1985-1986 for their role in conspiring to and depriving me of my rights to not stand trial in due process of law. I would also note that for this court or the chief judge to do anything other than dismissing this case will require those lower courts to assert authority from the Wisconsin Supreme Court pursuant the Wisconsin Constitution Act 7, Section 3, because to do so requires the lower courts to overrule, modify, or withdraw language from Armstrong versus State, 55 Wisconsin, 2D 282-198, NW 2D 358-1972. Interpreting. Time limit and lost jurisdiction, which only Wisconsin State Court can. Zander, VACUITY-A.MUT.INS.CO 2010, Wisconsin 35 PP-55-58-324, Wisconsin 2D 325-782, NW 2D 682, Your Honor.
All right, thank you, Mr. Anderson.
Yeah.
Okay, thank you. All right, now, first off, is the state prepared to proceed on the 3 felony files for preliminary hearing?
Yes.
All right, Mr. Celebre?
Likewise, Your Honor.
All right, then we'll take these one at a time. Has there been an offer tendered in any of these files?
Yes, there is a global offer in this case. The offer is plead to first degree recklessly endangering safety without the repeater in 20 CF 174. Plead to first degree recklessly endangering safety without the repeater in 20 CF 139. And plead to fleeing as charged in 19 CF 1449, including the repeater. The state would dismiss and read in the remaining charges in those 3 files, and at sentencing, the state would recommend prison, no specific length. The offer would be open to further negotiations and conditioned on the defendant complying with the terms of his bond. The offer would expire at the first judicial pretrial.
All right, thank you. And does that also involve the TR files, the offer?
So the state would be willing to dismiss those as part of the plea agreement.
All right, and that all 3 files, 20 TR 842, 843, and 844?
That is correct.
All right, thank you. Mr. Celebre, is that a correct recitation of the offer as you understand it?
It is, Your Honor. And I can say that my client has made clear both in writing with his pro se motions as well as his remarks in the past in these proceedings. He wishes to go forward and he does not accept this offer at this time.
All right, thank you. Is that correct, Mr. Anderson?
I'm standing behind my lawyer 100%.
All right, and now, Ms. McNeil, with respect to the offer and the hearings to be held, is there anything further from the state?
Well, that offer will be withdrawn with the hearings being held.
And with respect to future negotiations, are those going to be left open?
That will be up to the prosecutor who has the case in the end, but certainly the state is not obligated to negotiate further.
All right, Mr. Anderson, did you hear the offer that was just placed on the record in regards to those files?
Yeah.
Yeah, and did you have enough time, at least at this point, to discuss the offer with your attorney, Mr. Celebre?
No.
You did not have enough time to discuss that offer with him?
I wasn't even, the offer wasn't even in my vision. I'm still stuck on how things was just held. It's just a mess right now, Your Honor. I don't understand what's going on. I have a few questions for you. I don't mean to go off course, but if you would answer my questions, I would like to ask them, Your Honor.
Well, give me a second, just for a second here. What I want to know is, would it assist you, sir, to talk to Mr. Celebre more about 2 things, those questions you might have for me, but secondly, and to the point, at this point, about the plea offer that's been given to you?
I'm not willing to take anything, Your Honor.
No, I understand that, but I wanted to know if you understood the offer, and you had indicated you really didn't understand the offer. I really want you to at least be able to say you understand it before you reject the offer. And I would.
Yeah, I just don't want to be misconstrued, because in the past it was told that I waived some stuff voluntarily, and it was just a whole bunch of words circulated for me to just agree to something. I don't feel comfortable answering any questions. You could just ask my lawyer. He'll understand it more, Your Honor.
Well, what do you, here's my concern, Mr. Celebrity, you know, in terms of this offer, did you discuss directly with Mr. Anderson the offer as it was tendered?
I had at one time, Your Honor, prior to my first appearance on this case, and it was squarely rejected, and he wished to proceed with motions at that point. I have not since then gone over it once again.
Okay, well, 1 second, I believe we lost Ms. McNeil. She'll have to log back in, maybe.
Yana, may I ask you the questions real quick then, since we waiting on Ms. McNeil? I'm pretty sure she can still hear us.
I don't know if she can still hear us. That's why I have to wait until she comes back, because I don't see her on the screen, and I don't even see her logged in here at this point. So we have to wait for her to come back anyway.
Ms. McNeil is working on coming back into the hearing.
Hey, Yana, I don't mean no disrespect, but is Ms. McNeil gonna be the one that's giving me the answers to the questions that I'm seeking from you?
Probably not, but she has the right to hear the questions and the answers.
Okay, okay.
All right, Ms. McNeil, you can hear us?
Yes, I can. Sorry about that.
That's fine. All right. Now, Mr. Anderson, you have some questions.
Yes, it was regarding my motion. From my understanding, you denied it because I told
I'm
my
not going to
time
go,
or something.
excuse me, I've already ruled on your motion. We're not here for your motions anymore. We're here today for the preliminary hearings that you wish to have. I'm going to hold those hearings. The record that I made on denial of the motions has already been made. So if the questions are about the motions, I'm not going to entertain any further questions about the motions, Mr. Anderson.
No, it's just,
we're here.
It's just, I'm confused because
that's why you have an attorney.
Yeah, but if I'm asking you, but yeah, that's cool that I have an attorney, but doing through my pro se documents and motions, I had an attorney still, but I was still up to me to answer questions and to answer, right, Yana?
That's true, and that time has now passed. I have ruled on that. You're going to appeal my decision, which is your right, and that's why we're not going to revisit the motions again. We're going to talk about preliminary hearing today. That's what's scheduled for today.
But Your Honor, if I'm in the process of an appeal and I haven't been to bond over or preliminary, how is it that my stay is irrelevant to what I'm asking you? I'm asking you for a stay for any preliminary hearings and bond overs until we figure out this decision of what you made, Your Honor. It's already in the process. Last week you told me we couldn't do it because I didn't file it, but I filed it now. What's the problem?
The issue is I'm going to conduct these hearings. You preserved your right to have that heard, and I'm moving forward now with the preliminary hearings because there's been no stay entered. I'm not entering a stay, and no judge has entered a stay as well. So I'm going to proceed with the preliminary hearings. And again, if your motion at that point will be taken up, I believe, by Judge Russell, but at this point, we're going to move forward on these preliminary hearings. But I direct these discussions now with Mr. Celebre, your attorney. I don't know if you did talk to him about that, and that's between you and Mr. Celebre. I don't need to know anything that you two discussed. That's privileged. I'm here to talk about today 3 preliminary hearings that apparently we're going to hold. I had originally asked you if you understood the plea offer that was given to you regarding those 3 felony files. You indicated to me that you weren't able to focus on that because you were concerned about the issues involved with your motions. Now, I'm asking you again, if you believe it would be helpful for you to talk to Mr. Celebre again about the plea offers that were given to you.
But from my understanding, he already gave you the question and told you that I ain't want no motions, and that he did. And I just told him, don't even speak to me about it, young.
Okay, then we're going to hold those hearings. So let's call the first matter is the State of Wisconsin versus Vandell M. Anderson. That's filed 19 CF 1449. Is the state prepared to proceed?
Yes.
All right, Mr. Celebre, you prepared to proceed?
Yes, Your Honor.
All right, good. How many witnesses for the state?
1 witness.
Okay, and how many for the defense?
At this point, none, Your Honor.
All right, and then like I said before, just so you're aware, Mr. Anderson, what the state has said, since you're going forward in rejecting the plea offer, which is your right, the state is withdrawing the plea offer and has reserved its right to no longer negotiate in those files. It may negotiate, it may not negotiate, but it's preserved the right to not negotiate, just so you're aware of that. You understand?
I'm aware of a lot of things. Just
Okay.
as well I'm aware of they wasn't ready back in April 14th, you know? All this don't even matter. All this right here that's going on right now is irrelevant to anything.
That's fine.
Because you had the constitutional duty to appoint me counsel back then, and you didn't, you know?
Okay,
You
may,
did. I ain't had a fair anything.
call
yeah.
your first witness. May call your first witness. State.
The state calls Officer Skaronski.
Officer, would you raise your right hand? Solemnly swear. All right.
Before that, I wanted to let Assistant District Attorney McNeil know I don't have a complaint for this case. I only have the complaint for CF 174. I believe
You're gonna have to, then Ms. McNeil, then I can take 174 first, but I'm gonna need you, Ms. McNeil, then to submit those to your witness, 19 CF 1449 and 20 CF 139. Do you understand?
So the other complaint, the 20 CF complaint, should be with Deputy Gott. And then I will send the missing complaint right now.
All right, so which complaint is for this witness here? Just one complaint or 2?
This witness in the end will have 2 complaints. And so the complaint that is 19 CF, I don't know what the rest of the numbers, I will send to him.
That's 1449. And
Right.
then so is this witness prepared to testify to 20 CF 174?
I believe that is the complaint he has.
That's what I have.
Is that for Deputy Gott? Is that a Kenosha PD witness or Deputy Gott? Because there's another 20 CF 139.
That other case, 139, is with Deputy Gott.
All right, thank you. All right, then, so officer, you're prepared to testify to 20 CF 174, is that correct?
Correct.
All right, well, then I will call that case at this point. Then I'll call instead the State of Wisconsin versus Vandell M. Anderson, 20 CF 174. I assume, Mr. Celebre, you tell me you're prepared to proceed in all 3 of these files today, correct?
You're correct, Your Honor.
All right, thank you. Then, officer, would you raise your right hand, please? You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you.
Yes, I do.
All right, great. You may put your hand down. Would you state your full name and spell your last name for the record, please?
Andrew Skaronski, SKOWRONSKI.
All right, thank you. Ms. McNeil, your witness.
How are you employed?
City of Kenosha Police Department,
And how long have you been so employed?
20 years.
Before beginning this hearing here today, did you review a criminal complaint that involved a shots fired event on January 3rd, 2020 at approximately 1 p.m.?
Yes, I did.
And was that the location of that shots fired event in the 4700 block of 37th Avenue?
Yes, it was.
Is that location in the city and county of Kenosha, state of Wisconsin?
Yes, it is.
Now, based upon your review of that criminal complaint, did Officer Renteria speak to a witness named Samantha Siegman?
Yes, she did.
And what did Samantha Siegman indicate that she had seen in that location at that time?
She saw a black male by a purple Chevy Monte Carlo and heard 1 to 2 gunshots.
And did she indicate whether she saw who fired the shots?
Yes, that same black male.
And did she indicate what this person did after firing the shots?
That he appeared to put something behind the seat of the purple Monte Carlo.
And then what did Ms. Siegman indicate that she saw next?
Then she saw him get in the purple Monte Carlo and leave the area.
Did she indicate whether she saw any other person in the Monte Carlo?
No, she said he appeared to be the only person in the car.
And did Ms. Siegman provide a description of this individual she saw shooting?
Yes, she did.
And what was her description?
Black male with dreadlocks.
And did she have any clothing description?
I'd have to review the complaint, if that's okay.
Would it refresh your recollection to look at the criminal complaint?
Yes, it would.
And particularly referring your attention to page 2, the 3rd paragraph from the bottom.
Okay. I'm ready.
Is your memory refreshed?
Yes.
All right.
And so did Ms. Siegman give any clothing description?
She said he was wearing a baggy white t-shirt.
Now, when officers investigated this shots fired event, were officers able to recover surveillance video of this event?
Yes, they did.
And according to the criminal complaint, was that surveillance video reviewed by Officer Morton and Officer Koss?
Yes, it was.
And so what did those officers describe seeing on the surveillance video?
They saw a black colored Dodge Charger pull up by the purple Monte Carlo. They saw a subject who matched the description of the suspect get out of the Monte Carlo, walk to the back of the Dodge Charger, and shoot a gun at the back of the Dodge Charger. The Dodge Charger left the scene, and the shooter walked to the side of the Monte Carlo, put something in the back, got in the Monte Carlo, and also left the scene.
Now, according to the officer's review of the video, was there anything distinctive about the Monte Carlo?
Dark tinted windows and chrome hubcaps or wheel covers with one chrome cover missing on one wheel.
Now, I want to direct your attention to January 9th of 2020. Based upon your review of the criminal complaint, Was the suspect vehicle located on that day?
Yes, it was.
And did officers, when they located the vehicle, did they make contact with an Alan Melton?
I'd have to go back and look at the complaint. I don't recall that name.
So it would refresh your recollection to look at the criminal complaint?
Yes, it would.
So I am referring specifically to page 4 of the criminal complaint and the 3rd paragraph up.
And officer, when you're done and your memory's refreshed, please look up, place the document away and let us know that, okay?
Okay, I will. You said page 4, which paragraph?
The 3rd paragraph from the bottom.
Okay.
And so did officers make contact with an Alan Melton?
Yes, they did.
And did Alan Melton provide information about this suspect vehicle, the Monte Carlo?
Yes, he said he sold it to a person named Van, or who he knows as Van.
I'll object to
And-
this as to time when the event occurred without greater specificity as to when that may have involved Mr. Anderson.
What do you mean by your question?
We don't know, given the date of offense is said to have been January 3rd of 2020, and the encounter occurred January 9th with Officer Cawson Wickets and the other gentleman, Mr. Melton. We are not establishing by way of the sale who had possession on the date of offense.
Ms. McNeil?
So I have subsequent questions that I intend to ask the officer about the statement.
All right, well, then I'll overrule for now, but you may raise it again if the subsequent questions don't lay a better foundation, okay?
Thank you, Your Honor.
You're welcome. You may
Okay, so did Alan Melton tell officers, did he give officers information about having sold this vehicle to Van?
Yes, he did.
And what did he tell officers about that?
He told them that he sold it to Van, and then Van brought it back to him.
And what was the time frame that Alan Melton gave for when Van returned the car to him?
3 days, 4 days,
3 days or 4 days in relationship to what?
to when he sold it to him.
So do you have a recollection of the date when Alan Melton would have said that Van sold the vehicle back to Alan Melton?
I'd have to go back and look at the complaint.
So to refresh your recollection, if you could look at the 4th page of the criminal complaint, the very last paragraph.
Okay. Okay. I'm ready.
Okay, so based upon your review, did Alan Melton provide information to the police about when Van had sold the vehicle back to Alan Melton?
Yes, he did.
And when was that?
January 6th, 2020.
And at that time, did Alan Melton indicate that he sold a different vehicle to Van?
Yes, he did.
And according to the criminal complaint, was Alan Melton shown a booking photo of Vandell Anderson?
Yes, he was.
And did he identify that booking photo of Vandell Anderson as the person he knew as Van?
Yes, he did.
And was that with Officer Koss?
Yes, it was.
Have you reviewed a booking photo of Vandell Anderson?
Yes, I have.
And are you able to see if anyone on this Zoom hearing Can you identify anyone on the Zoom hearing as Vandell Anderson?
Yes, I can.
And can you provide a description of that person?
He's wearing orange, seated at a table just in front of a desk.
Well, let me ask you this. How do you identify the person you're identifying? Is that through the booking photo or something else?
Based on the booking photo that I have, I can show it to you.
I don't need to see the booking photo. I just want to make sure that Ms. McNeil, I need you to lay the foundation in terms of why this witness can identify, or why this witness is involved in identifying someone in this hearing a little bit better. So that's why I'm doing that. All right, so what you're reporting now is that you reviewed a booking photo in preparation for this hearing today. Is that correct?
Yes.
All right, Ms. McNeil, you may take the rest.
All right, and was the booking photo that you reviewed the photo of Vandell Anderson?
Yes, it was.
And based upon your review of that booking photo, can you identify anyone involved in this Zoom hearing as Vandell Anderson?
Yes, I can.
And please describe that person for us.
He's wearing orange. He's seated at a table and looks like he's seated just in front of a desk.
Okay, what's written, if there's anything written under where the person is seated on the screen?
KCDC PV Cart 2.
All right. All right, the record will reflect the witness has identified the defendant at this point.
Now, once officers had shown that booking photo of Vandell Anderson to Alan Melton, did Officer Koss compile a photo array containing a photo of Vandell Anderson?
Yes, he did.
And was that photo array shown to the witness, Samantha Siegman, by Officer Ruha?
Yes, it was.
And based upon your review of the criminal complaint, did Samantha Siegman make an identification based upon reviewing of the photo array of who the shooter was?
Yes, she did.
And so what was her identification?
She chose photo number 3, which was a booking photo of Mr. Anderson.
And she indicated that that person was the shooter?
Yes, she did.
Now, did Officer Koss also show this witness screenshots of the Monte Carlo, the suspect vehicle?
Yes, she did.
And was she able to identify whether that was the vehicle involved in the shooting she had witnessed?
Yes, she did.
Now, according to your review of the criminal complaint, did Officer Koss compare the person that he saw in the surveillance video with the description of the defendant?
Yes, he did.
And also based on a recent booking photo of the defendant that Officer Koss had viewed?
Yes.
And did Officer Koss believe that the person who was the shooter in the surveillance video matched the physical descriptors of the defendant?
Yes, he did.
Now, did officers actually recover shell casings at the scene of the shooting?
Yes, they did.
So they were able to determine that an actual firearm would have been used?
Yes.
And based upon your review of the criminal complaint, has the defendant been convicted of a felony in the past?
Yes, he has.
And was he convicted of the felony offense of possession of a short-barreled shotgun or rifle?
Yes, he was.
And was that conviction date from September 30th of 2016?
Yes.
And finally, was that in Kenosha County case number 15 CF 1172?
Yes, it was.
I have no further questions.
All right, thank you. Mr. Celebrate, you may cross-examine this witness.
Thank you, Your Honor. And I will start by asking Officer, looking to the criminal complaint on page 2, the second paragraph underneath the probable cause section. Have you had an opportunity to review that in preparation of today's testimony?
I read it prior, yes.
And that indicates that the vehicle involved in the shooting was a purple Monte Carlo, correct?
Correct.
And it was in fact a purple vehicle that was identified by the witness, Samantha, correct?
Correct.
And the vehicle that Officers Koss and Wickets stopped on January 9th, 2020, that was not a purple vehicle, was it?
I'd have to go back and look. It might have been the vehicle he had bought after we sold it back.
Well, if you need a moment to review the complaint, feel free to do so, directing your attention as you had reviewed on page 4, the second and third to the last paragraphs.
Okay, I'm ready.
And the complaint indicates that the suspect who was stopped by the name of Allen was operating a 2003 maroon Chevy Monte Carlo when it was stopped by Officers Koss and Wickets, correct?
Correct.
And when going back to the scene of the crime on the night of the shooting, the witness, Samantha, she was not able to identify by name the shooter or the person who discharged the firearm, correct? She gave
Correct.
a physical description but could not identify him by name, correct?
Might have frozen the image of the officer.
Oster, it's you guys.
I'm sorry, officer, I believe your image is frozen. Are you able to unfreeze that, or are you going to have to log in?
You're all frozen to me. Can you hear me?
We can hear you, but again,
It says my internet connection is unstable, and it's been like that all morning. I'll see if I can reconnect.
you want to, would it be easier if you just came over here to provide testimony, sir? That way we can avoid this going forward.
Yeah, you have, well, I have to prepare the other complaint as well, but I can come over and finish this one.
Why don't you do that?
Okay, give me a minute.
And I did email that, so if he can print it, then he can just bring that over too.
Then you're gonna have to give me about 10 minutes.
I got it. Which case was that? That you emailed?
20 CF 139.
Thank you.
Okay, I'll be over in a little bit.
All right, thank you.
Is Deputy Gott there?
Yeah.
I just want to make sure we're good to go on your case, Deputy Gott.
Yes, I'm ready.
Okay.
I was a girl in that, so I had to wait for her.
Everybody looks?
Yes.
All right, we're back on the record then for State of Wisconsin versus Vandale M. Anderson. We brought Officer Skronsky over in the courtroom here to testify as the internet connection was buffering where he was testifying from via the Zoom application. All right, we'll continue the hearing then at this point. Ms. McGill, Mr. Celebrate, you were involved in cross-examination.
Thank you, Your Honor. Let me just clarify. The witness on the night of the shots fired, officer, identified the shooter as getting into what was a purple Monte Carlo, correct?
That's correct.
And the vehicle that officers Koss and Wickets stopped on January 9th, 2020 was a maroon vehicle, correct?
That's correct.
Now, as far as the date of the shooting, that occurred on January 3, 2020, correct?
Correct.
And the date of the stop was, that is to say, the stop of Mr. Melton, that was January 9, 2020, correct?
Correct.
And when the officers, Koss and Wickets, looked at a booking photo of Mr. Anderson, this booking photo was from what date?
I'd have to refer to the complaint.
Certainly you may do so if it will refresh your recollection.
Mr. Celebrate, is there a specific location in the complaint you wish to direct the officer?
Thank you, Your Honor. I'm looking at the bottom half of page 4 from the paragraph starting with on January 9, 2020 to the bottom of the page.
Nothing on that page or a date for the booking photo.
Have you had an opportunity to review the complaint?
I'm looking for something that shows the date of the booking photo that he looked at.
And is it fair to say that the date of the booking photo is absent from the complaint?
I'm not finding it, so yes.
And secondly, the gentleman, Mr. Alan Melton, he gave what was a physical description of the buyer of the maroon Monte Carlo he was driving the day of the stop, correct?
Yes.
And Mr. Melton told police that approximately 3 or 4 days ago is when the gentleman later identified as Van, came to Mr. Melton and requested to return the vehicle that he had purchased, correct?
That's correct.
And the date of shooting was January 3, 2020, correct?
That's correct.
So you testified previously that Officer Koss compared a booking photo of Mr. Anderson to the surveillance video. And is it your testimony today that you have no knowledge as to when the photo of Mr. Anderson was taken that was used to compare with the surveillance video?
Yes.
Then I have no further questions of this witness, Your Honor.
All right, thank you, Mr. Celebrate. Any redirect, Ms. McNeil?
Yes, just to be clear about the timing regarding Alan Melton. Officer Skoronsky, did Alan Melton indicate whether this person, Van, told him anything about registering the vehicle?
Yes, he did.
And what did Van state to Mr. Melton?
That he had registered it in Illinois.
And then according to Officer Koss, when was the vehicle registered in Illinois?
I'd have to go back and look at the complaint.
So I'd like to direct your attention to page 5 of the criminal complaint, the second paragraph at the end of that paragraph.
Okay.
And so does that refresh your recollection as to the date the vehicle was registered?
Yes, it does.
And what was that date?
December 28th
Of 2019?
of 19, yes.
And who was the registered owner at that time?
Antoinette Nichols?
And according to your review of the criminal complaint, is Antoinette Nichols a girlfriend of the defendant?
Yes.
And then finally, regarding Officer Koss's identification of the vehicle that he found with Mr. Melton, was that vehicle distinctive in a way that matched the surveillance video of the suspect vehicle?
Yes, it was.
And what was that?
It had dark tinted windows and it had chrome wheel covers with one wheel cover missing.
I have no further questions.
All right, any recross, Mr. Celebrate?
No recross based on that redirect, Your Honor.
All right, thank you. Then your testimony is completed in this case, officer. All right, Ms. McNeil, any further witnesses for the state?
No, and I move for bind over.
All right, Mr. Celebrate, you indicated before, no witnesses. That continue?
You're correct, Your Honor. We have no witnesses.
All right, state's move for bind over. Your argument, sir?
Thank you, Your Honor. I would argue that there's not sufficient evidence brought forward at this stage of the proceedings, even with all inferences in favor of the state, as the sole witness has identified that an eyewitness to the shooting incident in early January identifies the shooter as coming from a purple Monte Carlo, and the surveillance shows that to be the case. And on January 9th, 2020, officers Koss and Wickets stopped a maroon Monte Carlo. The booking photo that's used to eventually try and identify Vandell Anderson as the occupant of the vehicle on January 3rd is a booking photo from a date we do not know when. And we cannot say the resemblance that it has of my client to that of the shooter. The state has left many options open with respect to the discrepancies in the vehicle color. Though there is a somewhat unique description of one hubcap missing, I believe that there are many ambiguities sufficient to defeat probable cause as to this being the same vehicle that was involved in the shooting. And I feel that there's not been sufficient link between the driver of the vehicle on January 3rd, who is said to have discharged the weapon, and the seller of the vehicle at some later date to Mr. Melton, based on the discrepancy of the vehicle as well as identification of Mr. Anderson. Thank you.
All right, thank you, Mr. Celebrate. Well, first off, all reasonable conflicting inferences at this juncture are decided in favor of the state. I further find that hearsay testimony is reliable for purposes of determining whether probable cause exists, and further allowable pursuant to section 970.038 of the Wisconsin statutes, and further pursuant to the case of State v. O'Brien, the 354 with second 753 is the site of 2014 case. That having been indicated, based upon the testimony provided here by the testifying officer, I do find that based upon that testimony presented today, I do find the state has demonstrated that probable cause exists, that a felony was committed relating to the counts in the complaint, and that probable cause exists that this defendant committed that felony. Therefore, the defendant is bound over to the Kenosha County Circuit Court for further proceedings. Will there be an information file today?
Yes.
Okay. All right. Well, I want to do these one at a time in case we get caught up in something. So I'd like to have take these one at a time. This one is 174, 20 CF 174.
I did send it to Attorney Philip.
Yes, I have received it.
All right, thank you. I do have this matter at this point. With respect, these are accounted in front of, is it these Judge Schrader cases at this point?
I believe they're Judge Russell.
Yeah, that's what I thought too. I have Schrader on this
Oh, really?
information.
Then let me fix that.
All right, thank you.
Okay, I am attempting to email that to your clerk and to Attorney Celebre,
All right.
but my
thank you.
computer doesn't want to do that. So it is currently locked up.
Well, then you're going to have to walk it over here, I guess, or have someone do that.
Or a friendly suggestion may be to strike the presiding judge on the information filed.
I'm perfectly happy to do that on the record if that is acceptable.
Mr. Celebre?
We would not oppose the modification as described.
All right, then we'll strike the reference to the Honorable Bruce E. Schrader, and instead this will be the Honorable Jason A. Russell. And I do have an information, again, and you acknowledge receipt of that information, Mr. Celebre, is that correct?
Yes, Your Honor, I have acknowledged, electronically received the information. I would acknowledge its receipt, waive its reading at this time, and enter a plea of not guilty to the charges.
Well, Judge Russell will conduct his own arraignment, so you don't need to enter the pleas at this point. Matters found over. And again, you preserved, Mr. Celebre, for the record too, you preserved your issues. Those are perhaps credibility of witness issues, which are not relevant for these proceedings, but the plausibility of the story is what's relevant for these proceedings for reference to bind over, but you preserved your right in regards to the witnesses in terms of your cross-examination. Okay?
Thank you. We would request an arraignment date then.
We'll set it up. We'll set it out for arraignment before Judge Russell, and again we'll strike Judge Schrader and instead insert Judge Russell. They're looking for an arraignment date at this point, then before Judge Russell. Yeah.
Okay, August 21st at 8:30.
That was the 21st?
Yes.
Thank you. That'll work.
Thank you.
All right, and bond will continue as previously posted. Now, we're going to take up the matter of 20 CF 139, and then finally we'll take up 19 CF 1449. I believe this 20 CF 139 involves Deputy Gott, is that correct?
That is correct.
All right, thank you. All right, now we'll move to the matter of the State of Wisconsin again versus Vandale M. Anderson, 20 CF 139. Appearances remain the same. State prepared to proceed to preliminary hearing?
Yes.
All right. Is the defense prepared to proceed to preliminary hearing, Mr. Celebre?
We are, Your Honor. Thank you.
All right. How many witnesses for the state
One witness.
or the defense?
We anticipate none.
All right. Thank you. Then you may call your first witness, Ms. McNeil.
The state calls Deputy Gott.
All right, Deputy, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you?
I do.
All right, you may put your hand down. Would you state your full name and spell your last name for the record, please?
Ryan Gott, G-O-T-T.
All right, thank you. Ms. McNeil, your witness.
Deputy Gott, how are you employed?
Deputy Sheriff for Kenosha County.
Before beginning this hearing today, did you review a criminal complaint involving events occurring involving a fleeing on January 30th of 2020?
Yes.
And did that incident occur at approximately 11:47 a.m. according to the criminal complaint?
Yes.
And according to the criminal complaint, was Deputy Tift involved in this fleeing incident?
Yes.
What did Deputy Tift indicate that he observed on January 30th, 2020 at approximately 11:47 a.m.?
Deputy Tift observed a blue Chevrolet Tahoe traveling northbound on I-94, approaching Highway 50. He indicated that the vehicle had extremely dark tinted windows and he was unable to see inside the vehicle. Deputy Tift said he activated his emergency lights to stop that vehicle. The vehicle initially pulled over for a very short period and then fled from the traffic stop at a high rate of speed.
So according to the criminal complaint, Deputy Tift would have been in a KSD squad car,
Yes,
and he indicated that he activated the emergency lights on that squad car.
yes,
Now you indicated that the vehicle initially pulled over, is that correct?
correct.
And then what did the Tahoe do after initially pulling over?
Deputy Tift indicated that he saw the brake light go off and then it accelerated rapidly up to, I believe he said 90 miles per hour.
So what did the this Tahoe do then after accelerating away from this traffic stop?
It continued northbound on the interstate, and in the area of Highway K, it passed a semi-truck on the shoulder. It then exited the interstate at Highway 158, ran through a red light. It then went westbound underneath the interstate, and then went southbound back onto the interstate.
And was all this occurring while Deputy Tift was following this vehicle?
Yes, and Deputy Tiff also indicated that when the vehicle fled, he activated his siren.
And so then what did the vehicle do after it began heading southbound on I-94?
The Tahoe passed two vehicles on the shoulder of the 158 on-ramp for the interstate. Deputy Tift indicated that they were traveling in excess of 100 miles per hour. The vehicle then continued southbound, changing lanes many times. In the area, as they were approaching 165, the vehicle attempted to pass another semi on the shoulder. However, due to some snow on the shoulder, was unable to, and it crashed into the trailer of the semi. It then continued to drive southbound with significant damage. It was smoking. The vehicle speed decreased slightly due to the damage to it. They continued into Illinois. Deputy Tiff was told to disregard the pursuit. However, he continued to follow the vehicle at normal speeds due to the damage to it and the fact that the bottom of it was on fire. He wanted to make sure the driver was able to get out if it were to become fully engulfed in flames.
So then just to be clear, everything that you testified to, including the point where the vehicle crashed into the semi-truck, all of that had occurred in Wisconsin?
Correct, in Kenosha County.
And then as the vehicle continued south, you indicated it then entered Illinois?
It went into Illinois on Route 41 and eventually came to a stop at 173. Deputy Tift and other deputies then ordered that, I believe the driver got out of the vehicle with his hands up, and they were able to take him into custody at that point.
And did Deputy Tift identify the driver of the vehicle?
It indicates that he was first identified verbally and then through a Wisconsin DOT photo, and he was identified as Vandell Anderson.
Now, in preparation for this hearing today, did you review a booking photo of Vandell Anderson?
I did.
And based upon your review of that booking photo, do you see anyone on this Zoom hearing that you can identify as Vandell Anderson?
Yes, Mr. Anderson is on the screen listed as KCDC PV Cart 2. He's wearing an orange shirt and a mask.
Well, I'm going to ask this defendant to pull down that mask. Sir, would you pull the mask down, please? All right.
That is Vandell Anderson, based on the booking photo that I reviewed.
All right, then now the record will reflect the witness has identified the defendant. Thank you, sir.
I have no further questions for this witness.
All right, Mr. Celebrate, do you have any cross-examination questions for the deputy?
Just briefly, Deputy, you indicated what was the initial one or set of reasons that Deputy Tift had to stop the vehicle operated by Mr. Anderson?
It was due to the fact that the window tint on the vehicle was so dark that he could not even see inside of it.
And where was Deputy Tift located when the vehicle occupied by Mr. Anderson passed him?
Um,
Well, was he idle or was he driving on the highway?
I'm not sure if he was idle or driving. I'd have to review the complaint if it says.
Then I would ask you to review the criminal complaint starting at page 2 under the probable cause section.
Okay, I reviewed it.
And based upon your review of the criminal complaint, was Deputy Tift operating his vehicle on the highway, or had he been stopped and passed by the vehicle operated by Mr. Anderson?
It was seen that he was operating his vehicle. He said he pulled alongside Mr. Anderson's vehicle.
And it was based upon the tint that he observed of Mr. Anderson's vehicle at that moment that he decided to initiate the stop, correct?
Correct.
No further questions then, Your Honor.
Thank you, Mr. Celebrate. Ms. McNeil, any redirect on the cross?
No, Your Honor.
All right, thank you. Then Deputy, your testimony is concluded. Ms. McNeil?
The state has no further witnesses and moves for bind over.
All right, Mr. Celebrate?
I would argue, Your Honor, that the state has not presented objective proof as to the tint of the window and is based solely upon the what is opinion of the officer with respect to that tint, and it may be plausible but does not rise to a level of probable cause to initiate the traffic stop.
All right, thank you, Mr. Celebrate. Well, again, the issue here is plausibility of the story, not the credibility of the witness. And as such, further, all reasonable conflicting inferences are resolved at this juncture in favor of the state. I further find that hearsay testimony is reliable for purposes of determining whether probable cause exists and is further allowable pursuant to section 970.038 of the Wisconsin statutes. And further pursuant to the case of State v. O'Brien, 354 with second 753, 2014 case. That having been indicated, I also find that there's a heightened level of review when a review of a booking photo constitutes more of a review than just a review of the criminal complaint alone. And further, based upon the testimony presented today, I do find the state has demonstrated probable cause that a felony was committed relating to the counts in the complaint, and that probable cause exists that this defendant committed that felony. Therefore, this defendant in this matter is bound over before the Kenosha County Circuit Court for further proceedings. Again, it appears that this information has Judge Schrader affixed. And then for purposes going forward, 19 CF 1449 appears to have Judge Schrader as well. I believe these are both, they're all counted to Judge Russell. Is that correct?
That is correct. I would move to amend both informations to reflect Judge Russell.
Mr. Celebrate?
No opposition with regard to the 20 CF 139. If we get to that stage with the 2019 case, Your Honor, certainly I would not oppose that amendment as well.
And we'll wait to see if we get to that juncture. But as far as 20 CF 139, then based on the request or motion of Ms. McNeil, no objection for Mr. Celebrate, court will allow the amendment in this case, or a striking of Judge Schrader for Judge Russell. And as such, this matter has been bound over now before Judge Russell for further proceedings, including arraignment, as Judge Russell will conduct his own arraignment. Nonetheless, Mr. Celebrate, did you receive a copy of the information?
Yes, Your Honor, I would acknowledge its receipt.
All right, thank you. And like I said, we'll have it calendared for arraignment before Judge Russell. And bond conditions will continue as previously imposed rather.
Arraignment August 21st at 8:30.
Thank you, Madam Clerk. That will work well.
All right, thank you. Now we will move to the matter of the state of Wisconsin versus Vandale M. Anderson. Case number is 19 CF 1449, set on for preliminary hearing. Is the state prepared to proceed?
I believe so.
All right, Mr. Celebre.
Yes, Your Honor, we are prepared.
All right, thank you very much. Okay, Ms. McNeil, you may call your first witness.
The state calls Officer Skronsky.
All right, officer, would you raise your right hand? You solemnly swear to tell the truth, the whole truth, and nothing but the truth shall help you?
Yes, I do.
You may put your hand down. All right, would you state your full name, sir, and spell your last name for the record?
Andrew Skowronski, SKOWRONSKI.
All right, thank you. Then, Ms. McNeil, your witness.
How are you employed?
City of Kenosha Police Department.
Before beginning this hearing here this morning, did you review a criminal complaint involving events occurring on May 21st, 2019 at approximately 9:28 p.m.?
Yes, I did.
According to your review of that criminal complaint, on May 21st, 2019 at approximately 9:28 p.m., where was Officer Koss located at that time?
71st Street and 16th Avenue.
Is that location in the city and county of Kenosha, state of Wisconsin?
Yes, it is.
According to your review of the complaint, did Officer Koss observe anything that caused him concern?
Yes, he did.
And what did he observe?
He saw a red Kia fail to stop for a stop sign at that intersection.
Then where did the vehicle go after failing to stop at the stop sign?
I went to the area of 69th Street and 16th Avenue.
Now, when the vehicle had just left the intersection of 16th Avenue and 71st Street, did Officer Koss note anything about the speed of the vehicle?
He observed that it appeared to be moving faster than 25 miles an hour, which is the speed limit in a residential area.
At that point, then, did Officer Koss attempt to catch up to the vehicle?
Yes, he did.
And during this time, Officer Koss was also accompanied by Officer Ruha, is that correct?
Yes, he was.
So was Officer Koss able to catch up to this suspect vehicle?
Once the suspect vehicle parked.
And what did Officer Koss indicate that he did once the suspect vehicle had parked?
He parked his squad by that suspect vehicle and approached the driver's door.
And do you know how the squad was situated in relationship to the suspect vehicle?
It was about 10 feet from the front of the vehicle.
When Officer Koss so situated his squad, did he do anything else?
Activated his emergency lights.
And so that would be the red and blue lights on the squad?
Correct.
Did Officer Koss then approach the suspect vehicle?
Yes, he did.
And did he speak to the driver of the suspect vehicle?
Yes, he did.
Did Officer Koss indicate whether he was able to identify the driver of the suspect vehicle?
Yes, he was.
And who did he identify the driver as?
Vandrell Anderson.
Is that Vandell Anderson?
I'm sorry, Vandell Anderson.
And did Officer Koss confirm that identification subsequently with a booking photo?
Yes, he did.
Did Officer Koss make any observations about the driver of the vehicle, Vandell Anderson?
He was sweating profusely.
And then did Officer Koss eventually, during the course of this encounter, see anything in the vehicle that caused him concern?
He saw the corner of a baggie by Mr. Anderson's arm.
Did Officer Koss ask Mr. Anderson what was in the baggie?
Yes, he did.
What happened at that point?
Mr. Anderson held his arm down Didn't show Officer Cost what was in the baggie.
And after that point, without showing Officer Cost what was in the baggie, what did Mr. Anderson do then?
He put the car in gear and began to drive away.
Now, at this point, the traffic stop was not over, correct?
That's correct.
And did the defendant drive away? Did the defendant hit anything when he drove away?
He hit Officer Cost in Ruha's squad car.
And were officers able to follow him and apprehend him at that point, or no?
No, they were not.
Before your testimony at this hearing this morning, and in preparation for your testimony, did you review a booking photo of Vandell Anderson?
Yes, I did.
Based upon your review of the booking photo, are you able to identify anyone in this Zoom hearing as Vandell Anderson?
Wait, I'm gonna, Mr. Anderson, or excuse me, would you lower that? I want to see if this officer can identify without the mask. I assume the booking photo doesn't have a mask. Now that question, Ms. McNeil.
So Officer Skronsky, based upon your review of the booking photo of Vandell Anderson and what you can see on the Zoom phone call, can you identify anyone as Vandell Anderson?
Yes, I can. He's in the Zoom window that has a title KCDC PV Cart 2. He has a mask hanging from his ear and he's wearing orange.
All right, the record will reflect the witnesses identified the defendant.
I have no further questions.
All right, thank you. You may cross-examine this witness, Mr. Celebrate.
Thank you, Your Honor. Just briefly as to identification, Officer Skrovansky, the booking photo that you looked at for purposes of today's hearing, that came from 2020, correct?
That is correct.
And the photo that you testified Officer Koss reviewed of Mr. Anderson, that the date on which that booking photo was taken occurred prior to the stop on May 21 of 2019, correct?
I would assume so, yes.
Therefore, clearly there are two different photographs of Mr. Anderson or someone purporting to be him that you and Officer Koss respectively reviewed, correct?
Correct.
And with regard to the basis for the stop on May 21 of 2019, this was initiated by police based upon the speed at which Mr. Anderson is said to have been traveling, correct?
I think the initial reason for the stop was failure to stop at a stop sign.
Okay, so based upon his failure to stop at the stop sign, was that compounded or was there a second reason of his traveling in excess of the speed limit as well?
I don't quite understand your question.
Were there two reasons why the officers initiated the stop, or was it solely due to his passing through a stop sign?
Complaint doesn't state that exactly.
And there was never any controlled substance in the vehicle driven by Mr. Anderson on May 21, 2019 by police, am I correct?
If you're asking, did the police find any controlled substances in the car? Then no.
Thank you. Then I have no further questions.
All right, thank you. Ms. McNeil, any redirect for the officer?
No redirect.
All right, thank you. State has no further witnesses, correct?
That is correct and moves for bind over.
Mr. Celebrate.
Thank you, Your Honor. Again, we would oppose the bind over on the basis that this was a traffic stop that was initiated. There's no evidence given of any citation that was issued in this case as a consequence of the stop. It either was a perfunctory stop or the purpose of the traffic stop had passed and my client was not being detained on any alleged drug charge at the time. Therefore, he was free to leave. I believe that there is no sufficient evidence to bind this case over on a felony. Thank you.
Thank you, Mr. Celebrate. Once again, I do find that all reasonable conflicting inferences at this juncture are decided or resolved in favor of the state. Further find that hearsay testimony is reliable for purpose of determining whether probable cause exists and is allowable pursuant to section 970.038 of the Wisconsin statutes and further allowable pursuant to the case of State v. O'Brien, 354 with second 753, a 2014 case. Further find again that a review of the booking photo constitutes more of a review than just a review of the criminal complaint alone. It's a heightened level of review. And that, again, based on the testimony presented today, I do find the state has demonstrated probable cause that a felony was committed related to the counts in the complaint and that probable cause exists that this defendant committed that felony. Therefore, this matter is bound over to the Kenosha County Circuit Court for further proceedings. Now, once again, on this information that's been filed, I do see here that, again, once again, Judge Schrader's name is affixed.
That is incorrect. It should be Judge Rossell, so I'm asking for leave to amend it on the record.
No objection, Your Honor.
All right, thank you. Then leave is granted and the matter of instead of Bruce E. Schrader being affixed to the information will be Jason A. Rossell. The matter will be calendared for arraignment before Judge Rossell. Now we have the TR files, I believe. Now, Mr. Celebrate, do you want to wait to enter pleas on those for the arraignment, or do you want to enter those today?
We would like to enter all pleas at the arraignment, Your Honor.
Okay, then you're probably going to want, is there, you need to substitute on those TR files, I believe.
Very well.
You want to do that now, and then I'll allow it to happen and to occur right now. You've as timely if you'll file the substitution request. Very near.
I would like to do so, Your Honor. Unfortunately, I don't have the capability at this very moment to file the substitution on the TRs.
No, I'm not going to require you to do it right now. I just want it done in the future. But are you requesting a substitution on those TR files?
Yes, they would be as companion files.
All right, then substitution request was made of a timely filed, if you will, and it'll be in its proper form. I'll order that the TR files, the substitution will be granted to Judge Rossell as well, and they'll trail the CF files.
And the date for the trailing TRs and the last case, the 19 CF case, will be August 21st. And that'll be at 8:30 with Judge Rossell. Thank you very much, everyone.
Once again, bond conditions are retained. All right, thank you, everyone. That'll conclude the hearing.
Thank you, Your Honor.
Thank you.
Thank you.